All right. Good morning, beautiful humans. Welcome to Tuesday. Another fantastic day in all of our lives, I'm sure. Uh so what's going on? What's good? What's good? Before I say anything, welcome to Defense Diaries. I'm your host, Bob Mata. And we're gonna do a couple things today. We're obviously on verdict watch, which I'm sure many of us are a little bit surprised. The jury is very much taking their duty to deliberate very seriously. So that's, you can never spite them for that. That's what they're supposed to be doing. I think a lot of us felt like this thing was open and shut, including myself. Um, but that hair thing, I said it when we were watching it before he put the little hair arrow up there. I'm like, but the hair, what's up with the hair? The hair is weird. The hair is strange. Dizzy and I were chatting. She's like, well, it could definitely be a wig. Yeah, I mean, it could be. It could be a wig. I don't know. This case is so hard to put your finger on just because there's so many blunders by Tejas if he's the guy that it's like you have the one hand where he goes through a lot. If he's the guy, if he goes through a lot of work to try to cover his tracks. And on the other hand, you've got these things where it's like the most idiotic way to commit a crime, like using your own vehicle, making sure that it's caught on video. Yeah, like there's so many things like getting rid of the jacket and the knife, but keeping the hat and the shoes, stashing them in the house. It's a really weird case. It is a really weird case. And the other thing that we're gonna do will be keeping an eye on Kouri Richins. I fully intend on streaming the end of that. Hard to hearing. Just because that is a case that as it progresses, Allie and I are gonna be digging into. That's gonna be like Adelson is for Jay for Allie and I. It's just a sad, another bizarre case with just such a weird fact pattern. Um, but before I do any of that, how about Dizzy? Can we get some love in the chat for my ride or die, the indispensable Dizzy who just manned the ship after I left and went to go spend time with my daughter in her first softball game. I couldn't be more thankful, and she crushed it per usual. Like she does everything. She does everything well that she puts her mind to, and I'm very thankful to her. So I'd appreciate if y'all would show Diz some love in the chat because she deserves it. Not just for that, but like everything she does. She mods me all the time. I do not know when she sleeps. I honestly do not know when she sleeps. I don't know if she does sleep. I'm starting to think that Dizzy never sleeps. I mean, if you look at the work that her and Tracy put in on Seeking Justice discourse channel or Discord channel, I mean, and then just everything that she's doing with me, with Jay, with Steve and Dan over at PB. I mean, I honestly don't know when she sleeps. On top of that, she's in a different time zone. So kudos to my friend. You know what they say: teamwork makes the dream work, and I couldn't be doing this without Dizzy. I'll tell you that right now. So thank you, Dizzy. I just wanted to give you a lot of love this morning because you deserve it. So what I want to do is I want to see. So I was exhausted yesterday when I got back from the game. We went out to eat, took my dad out, and then I got home and I literally passed out. I think at 8:30 and slept until about 7:30 this morning. It was like I was tired. It was a great game. Two great. It was the A and the B team. Scout just picked up volleyball, so she's B teaming. It was great. Both teams won. It was a lot of fun. Went out and celebrated afterwards for her first volleyball game. We all had a blast. So that was great. Um, so what I want to know from you guys. So the point of me telling you all of that was that I did not, I didn't go back and watch any of Telus or Tejas. I don't know what the questions were. I know that there were a couple of questions relating to the video. I'm curious if you guys can let me know in the chat. Like, I think there were a couple questions. Let me know what they were. I didn't get to go back and watch them. Questions always really can kind of give you a pretty good idea of where the jury's head may be at, or at least one of the jurors' heads is at, right? I mean, we have no idea what's going on back there. We have no idea if it's one juror, if it's 11 jurors, like where they're at with this thing. We just don't know. All right, so let me see. I don't know. So we're on verdict watch. All right, I'm going to pull that up. So I've got that just sitting here. And we will keep a very close eye on that to see whether or not there's more jury questions. I think they're due in a few minutes. So we will closely monitor that. The word on the street is that the Richins preliminary hearing is supposed to start up around 11 my time, which would be 10 their time. Okay, wait, let's see. All right. Pokey, tell me more. What's this? What's the hoodie hair video? Is that a thing? What is that something that I'm supposed to look for? Diz, do you know what they're talking about? It sounds like, oh, I know what you're talking. I've seen those. Where you put the hoodie up and it's got like either like a mohawk or like a flat top type do, right? Like something like that. That's easier than a wig though, right? I mean, because the funny thing is that when you look at that photograph, the one that they were showing of kind of like they have it from both sides, where you can see the driver, one from a passenger's view. Obviously, they were able to find a camera on the opposite side of the driver's side, and then they show it from the other side as well. It definitely looks. It doesn't look like a hat, at least not a baseball cap. It doesn't really look like a skull cap to me. It does look like somebody with like prominent hair, which we know Tejas does not have. Yeah, the visor's the Guy Fieri hair, like something like that. That's something that I see at Bears games a lot. Like dudes will wear those things. But the one thing that I have noticed about those, hold on, I want to see if I can pull this up. Those photographs is you can definitely see that the driver's got something orange on, right? Which to me, again, and the state did a pretty good job of trying to probably ease the jury's, I wouldn't call it fears, but concerns with the fact that the inside of the Tahoe, the Denali, that when they processed it, they didn't find any kind of blood. Now we know that Tejas cleaned the outside of that and the two other vehicles. What we don't know is when and if he cleaned the inside, which is the far more problematic part of the vehicle that you would think when trying to cover up a crime that you would have to clean very, very thoroughly. And the fact that he has that whoever's driving that vehicle has this orange, we don't know if it's the same safety jacket. I can't tell if it's short sleeved. It kind of looks short sleeved. We know that the killer has a long sleeve orange jacket on, but and we know because we see the killer drive back to the car or a crime scene, get out of the vehicle, go check where Jeff German's body is, and then run back, that the killer got into the vehicle with that jacket on. Okay, because it's always, I've had cases. I've literally tried cases where, the homicides were committed by sharp object, and theoretically there was a huge amount of blood, and you're trying to figure out, okay, well, how is none of the blood tracked back into the vehicle? Like, and we're talking microscopic. I mean, like, obviously anybody's going to be able to wipe down visible blood, but in terms of the microscopic, and in terms of getting every single square inch of that vehicle wiped down so as to not leave anything, and beyond that, you had, as a offender or perpetrator, you have the issue of knowing that law enforcement has the ability to be able to identify when cleaning products have been used, which is always used as indicia of guilt, especially depending on when the cleaning of the vehicle takes place, right? So we know it's not just that they can determine uh, if blood is in the vehicle. They can also determine whether or not uh, the perpetrator cleaned the vehicle. So, I mean, I agree. I thought, whoa, Nav the EO. I have not seen you in so long. Thank you so much for that incredible generosity. Wow, that was amazing. Thank you so much. We've been missing you. We've been missing you. And like, as soon as I see Nav the EO, it immediately reminds me to tell you guys tomorrow, which seems to be a relatively quiet day, at least in terms of Tejas, unless this thing's still going. In terms of deliberations, Richins is anticipated to end today. Um, Tomorrow, I am like during the daytime, and I know that I typically do my Delphis at night. I plan on doing like an afternoon Delphi because there's been a lot of filings over there. Um, I know there's this weird buzz that uh, that people think, that certain people think that Allen's going to plead out. From what I'm seeing with the amount of filing that's going on, and look, Allison and I have taken cases up to the wire without giving any indication to the state that we're going to plead out. But the way that that really works is you have to prep for trial. All right. And prepping for trial is a lot of work, especially if it's a big trial, especially if you intend on calling tons of witnesses that you have to arrange for their travel and their boarding, and making sure that they're fed, and trying to coordinate between everybody's busy schedules. Oh, look at this. That makes so much more sense. I've been out of the country for 3 months. I've come back, and it seems like the court has lost its minds. So good to be back and see you again. Ditto, Nav. Ditto. We've missed you. I was worried. I didn't see you for so long. So welcome home. I hope you had an amazing time out of country for 3 months. And that is, per usual, just incredibly generous. And I'm sure that the 50 people that were lucky enough to get memberships from you are equally thankful. Incredibly generous person. Always just blows my mind every single time. Thank you so much. But to kind of get back to it, just you have like earmarks of things that you can tell when trial is bearing down, whether or not uh, a plea is in the works. And in my experience, the state, because of what I was going back to, just talking about how much work it is prepping for trial, you always have the state saying, look, we're giving you a date. If they've made an offer, a plea offer, they're saying this, like, we're not going to allow you to string us along while we're putting in all the work for trial, only to have you turn around on the eve of trial and pleading out. Because then what you've done is you've wasted all of our time. So, you know, I'm not getting that sense here at all. We're seeing lots of filings taking place. We're seeing Dizzy sent me the most recent ones from this morning. We've got attorneys that are entering their appearance on behalf of people that the defense is trying to depose, trying to quash those subpoenas. And none of those things smell like a plea to me. On top of the fact that the amount of litigation that's starting to go on, we saw the 3 days of hearings. We see the pretty consistent filings by the defense. None of that has the earmarks of a plea, and we have no idea if they've made a plea offer. I mean, I'm in a case like that with facts like that, which, as I've made very clear, in my opinion, not including the 61 confessions, but looking at the facts in terms of the evidence that they've put forth, is not strong. Now, that doesn't mean that they don't have more. They could absolutely have more, which they developed after the arrest, post-arrest, because as I've said before, many times, those people out there that typically haven't practiced law, that talk about probable cause affidavits, and when the state puts them out, that they hold back some of the strongest evidence. That's not the way that works. That's not what happens. Whatever they have at that time that's powerful, they're going to put it out there because it's number one, they know it's going to be attacked by the defense in terms of trying to quash it, the arrest. So they're not going to put out a big, something that basically just crosses the threshold of probable cause, and is iffy. If they have powerful evidence, they're going to put it in there, because number one of that, and number two, because that is what the media and the public latches onto. So, that becomes the narrative, and they want the narrative in the public to be leading into trial, which can take 1, 2, 3, 4 years, to be that they have a very powerful case, that this is the guy. They want everyone walking around thinking they got the right guy. So for those two reasons, that does not happen. And I'm not talking about in every single case, but in every single case, you're not talking about high profile murders. Again, I tell you guys all the time, like a vast majority of cases are not the cases that we watch. That does not make up the legal system. These are the 1% cases that we watch, literally. So yeah, tomorrow I plan on doing a live, probably like high noon. Get a bunch of Delphi stuff done. The other case that I'm like really starting to feel like I'm missing the boat, which Jay and I covered for a few joyous days there, was YSL with Woody, who's still on the stand. The state has finally finished their direct examination of him, and now yesterday and today, Brian Steele, who is Jeffries, the main defendant, his attorney is crossing him. And from a purely academic and law nerd perspective, I feel like I've abandoned ship. I feel like I owe it to you guys. I owe it to what I do, what I stand for on this channel, that we need to be watching that. So like I feel like I'm missing the boat on that. So like, I'm going to try to figure out whether it be, I pull clips and do a live with the review, which is what Allison always wants to do. She's like, why do you sit there all day? We could just do reviews. I'm like, because that takes a ton of work. Like, and I like chatting with you guys. Like, that's the part. But I mean, we can chat during lives too, but it's different. It's a different thing, right? When we're doing a live and when we're watching a live trial as it's happening, it's a different vibe. I like both very much. I love watching trials with you guys. I just enjoy it because we're getting that initial guttural reaction to things that we're seeing where I'm not hearing about it, reading about it, and then covering it later. It's kind of like we were talking about with an excited utterance yesterday, right? With the hearsay. Same concept. I like that. I like when Jay and I give excited utterances about things that we're seeing that happen on these crazy trials we watch. So that's something that I've got to try to figure out because I really do feel like it's an important trial. It really is. It's such a important trial because of just it really reflects on kind of the state of our country in general, the state of minds of people with respect to how they observe different cultures, what they think about different cultures, the concept that they use the lyrics of rap artists, vast majority who are black, and use their words that are written in the form of art against them to try to convict them of crimes. That's like a very, like a very deep part of the premise of that case by the state over there. And you've got just this guy Woody who's like really spitting truths on that stand, coming from a life that many of us just have never known, will never know, never experienced. And that's, if you grow up in an area where gangs are prevalent and the cops are on your ass all the time, and there's a constant fear of them pulling you into that station and you never walking out. I mean, like, he's just spitting truths that I have no idea what happened over there after. And it's like, it wasn't a hearing, it was a status. It was a status call. They call it a status hearing. Kept trying to explain to people. Like, people are like, "Oh, he's pleading out." I'm like, "No, a status hearing is like, we typically have them every 30 days." What's up, Kaylin? Welcome, girl. Every 30 days in a typical case. And it's literally that. We are giving the judge, because judges don't micromanage what we're doing, the state and the defense, on cases. The judges have a ton of cases on their call, and they on every single case they have status hearings where you're coming in and you're letting the judge know, this is where we're at. This is where the state says, yes, we've tendered all of our discovery. We think that we're in compliance. The defense is saying, okay, well, they're saying that, but we think we need X, Y, and Z. The defense, well, we plan on filing a motion to suppress. We've got a couple of motions we're going to, so it's housekeeping, and it's allowing the judge to keep the case on track because they don't know. Malo hasn't started yet. Remember, the way that the judge out there works the Richins preliminary hearings is that they start the hearings, and then an hour later they allow it to be streamed. So Dizzy tells me she thinks that it's going to be around high noon. So we'll keep an eye on both those things. I've got Tellus up. I hope that Dizzy has Richins up so that when that goes live, we can. Thank you, Dizzy. Thank you. So when that pops up, we'll pivot right over there. And then obviously, if we get a verdict in the middle of, that's the nice thing about being able to pause, right? We're not really missing anything. So if the jury comes back here, we're obviously going to go boop, pop right over there, and see what's up. Oh, I got all excited. Went black on the Tellas thing. Tejas. Oh. got to see some behind the scenes stuff going on there. Jury's deliberating. So, all right. So I'm trying to get through all the housekeeping. So tomorrow, Adelphi live. Oh, interesting. Oh, all right. She's got I got all excited. I thought we had hot mic, but it sounds like she's yeah, she's handling other cases. It sounds like she's got some other cases on her call. I got all excited too, Diz. I saw it, I heard it. She just called the case and it was not. You know what? Might as well just throw it up here. Might as well. Let's see what's up here. Keep an eye on that thing. All right, so Delphi tomorrow, like I said, probably around noon my time, so 1 Eastern. And then tonight, I'm super, super excited about it. Again, like I don't know what I have to do to get people to start opening their eyes and their minds to like what I'm doing with Bill Dorsch, not just the Gacy stuff, but the Guevara stuff. It's just like I got like Tellez, I get, we stream a trial, I get 6,000 views on it. I put on this amazing documentary filmmaker who's been following the horrible, horrific, terrifying story of dirty cop Ronaldo Guevara, who's put 57 innocent people in prison on murder beefs, and they've all done huge chunks of time. Some of them have died in prison. 44 of them have been exonerated. This isn't like, oh, maybe he's a dirty ass cop. The worst of all, maybe ever. And I just can't get any traction on this. I got like 1,100 views on that thing. So that's not going to stop me, because I think when the Guevara story breaks, when that documentary comes out and everybody's minds are just blown about how terrifying it is when you've got a bad human being that's a cop who just has no respect for human life at all. People are going to come back and watch that stuff. They're going to come back and watch it. And so tonight, I'm very, very excited. Of course, I'll have Bill. Bill seems to have figured out the tech on his end, but I have Jacques Rivera, who happens to be one of the exonerees of Ronaldo Guevara, and happens to be the very first one, the very first exoneree, the very first person that was exonerated, and who really was instrumental in getting that movement started. Jennifer, thank you so much for that. Margaret said 2026 is her early 2026. Yeah, no, I know, C-Dub. It's because people just sit there and watch Discovery ID and think that they always get the right people. It's so weird. It's so weird. They think that all cops and prosecutors are heroes, and they're not. They're just not. Are some cops heroes? God, yes, absolutely. Bill Dorsch. I mean, one thing no one can ever say about me is that I'm like Bill Dorsch is a cop, lifelong cop. Love Bill Dorsch. I love great cops. I love and support great cops. Just do. I respect the hell out of good prosecutors, honest prosecutors, prosecutors that actually care about justice over convictions. I respect the hell out of them. They're absolutely necessary. We need them to get the monsters off the streets, the real monsters, the actual monsters. But to just focus in on convictions and justice and the truth being a casualty in terms of them just being concerned with convictions is untenable for me. So I have to be the resistance. I have to be the watchdog, and that's what I am. That's what I do. It's big part of my channel, And I know that a lot of y'all are, and you guys know, if they got the right guy, I'm all about punishment. So this is it. Like, I'm not that guy. Everybody's innocent. That's not me. You guys know that. I've been with y'all for, if you've been listening to my podcast for 3 years, that is not me. That is not what I do. If a guy's a steaming like pile of shit, then I hope he goes down always. So, but tonight, 9 p.m., if you want to hear a true horror story, because there are victims in all different types of way in the criminal justice system. Obviously, the victims of crimes, but when you have a system like ours in this country where tunnel vision takes hold and they're just dead set on getting a conviction and they railroad the shit out of people, it's a terrifying prospect. And I think that it would behoove all of you, who we all kind of live in our own lives and we can't even imagine what it would be like. I mean, could you imagine for 1 minute, like living in a hood where a lot of violence takes place, but you've never done anything in your entire life violent, and that you get picked up by a cop one day and that cop tells you, yeah, we got a witness that says that they saw you shooting that victim, and then the thing makes it all the way through trial and they convict you and you're innocent of it, and then you spend 2 decades in prison, missing your children growing up, missing your family, missing weddings and funerals and everything that makes our lives what they are, missing all of it because of some scumbag cop. So you're going to hear an actual person that's lived that tonight. And I think it's important. I think it's worth your time. Once again, like I said it last week, we all watch kind of the same stuff over and over and over about the same cases. Well, I'm trying to bring you some new content, open some minds, open some eyes, open some hearts. So hopefully you'll join. And if not, if you can't join live, please replay crew it. We think it's important. This is original content, like truly original content. It's I just think it's so important. So I'll quit whining and sniveling and get off my soapbox, but I implore you to watch it, because I look, I'm like, wow, 1,100 people have watched this amazing story unfold. And it kind of breaks my heart a little bit. It's like, it's such an important thing for every single person on this planet, especially in our country. But corruption happens everywhere, all around the world. So, just give it a peek. Whether it's tonight or tomorrow or the day after, or driving in your car. Bill told me, now I've never met Jacques, and Bill says that he gets excited. So I love which means that he's animated, and I'm here for that. So I can imagine tonight's going to be a lively live where he's going to be very much one of those guys that's very much like me. I am a heart on my sleeve guy. That's way I can't. That's how I'm wired. Like, I wear my heart on my sleeve. I don't keep much back. If you watch anything in terms of my content, immediately you're going to know a lot more about my life than you do probably most creators. Like, Jay and I are both like that in the sense that we talk about our lives quite a bit and what's going on in our real life. That's why we're so tight. We're cut from the same cloth, and I have a feeling that Jacques Rivera is going to be the same way, except his story is going to break your heart. And he got paid. I mean, you're going to be listening to a millionaire. He got a $17.5 million settlement. And I think it's going to be interesting for you guys out there who think that money cures those wounds. I think that's going to be a real eye opener. You know, when you see how passionate he is and how upset that he was robbed of all those years, still, despite having the money. You know, I think it's going to be interesting. I think it's going to be interesting. And what else? What else we got? Oh, so did anybody give me any let's talk about this Tejas thing. Let's talk about it. I want to know what the questions were. Were you guys able to give me the jury what the questions were? Nav the EO. Your work with Bill in those interviews are amazing. Thank you so much, Nav. You and Bill are what led me to your stream, and they are amazing. Thank you so much. If anyone hasn't seen it, man, you're awesome. I appreciate you more than you know, Nav. Thank you for saying that. I really do appreciate it. Sharon. Family hug. Welcome. We love having you here in the community. Shayna Ray, I'm so glad I found you in this community. I was not a fan of defense lawyers. Sorry, no apologies necessary. I mean, you can't know anything if you've never been in the system, if you've never required the services of a defense attorney, if none of your family has ever required the services of a defense attorney, and your entire basis of what defense attorneys do is coming completely and totally from the content that you watch on Oxygen, Discovery, even like the fictional stuff, Law and Order. You know, I mean, they paint us as slippery bottom feeders that are trying to get guilty people off of crimes, and it's not what we do. It is not what we do. It is not what we do. We advocate for you, all of you, the public. We are the only people on the planet, the only people on the planet, in this country at least, that are protecting your rights from the government, because there's no one else that can do it. They're literally, like when we file those motions, I tell this all the time, but I have to assume there's always new viewers. So those that my mantra, this thing that I talk about all the time, but that when we file motions saying that cops violated the constitutional rights of a criminal, that we're doing that because if we don't call them on them violating people's constitutional rights, what do you think is going to happen? They're going to think that they can do it whenever the hell they want, that they can take whatever measures they need, that the rules, that our rights don't matter because trying to get bad guys outweighs our rights individually. And we want bad guys off the streets. We do. And you know what? Good cops that follow the law, they're heroes. And if they do the work and they follow the evidence and they get their guy, you know what I'm not doing in those cases? I'm not filing a motion to suppress. You know why? Because I don't have the grounds to file it, because they did it by the book. It's that simple. Like it's that simple in terms of explaining what defense attorneys and our role in the system and what our like we have to look at law enforcement and the prosecution. They are the government. I mean, make no bones about it. They are all government employees. They are paid by a county. They're paid by a township. They're paid by a city. They're paid by a state. They're paid by the U.S. government, whatever the case may be. They are all arms of the government. And just understand that the Constitution, that document, which I, again, implore all of you, take a peek at it sometime. I know it's just this piece of paper that you hear people talking about, especially lawyers, and during election cycles, you'll hear the politicians talking about it. But it is literally the backbone of our society. Our country was formed on that document. Like, we created a whole new little system of government that had never been done before. And part of that was the judicial system. We kind of modeled it after common law with the crown over in the UK, but we tried to do better. There were things about that when the forefathers were drafting the Constitution, like, yeah, I don't like that part of it. We need to do better. We want to have, people can't come in presumed to be guilty and they have to prove their innocence. We're going to do it the opposite. They're going to come in that they're presumed innocent, and we're going to put the onus on the state, the government, to prove that they're guilty. And from that, that's everything that you see now. That burden matters. You absolutely should require that in every case, that the government does that, because you never know when that it could be your brother, your father, a loved one, a friend that gets sucked into the system. And once they're sucked in, it just chews you up and spits you out. And the likelihood of you ever getting out, innocent or not, is slim and none. It's like people look at it like, oh, like you can pull up like exoneration websites and look at the number and be like, well, gee, that number is not as huge as I would think. Well, that's because a vast majority of the people in prison that are innocent can't afford a lawyer, or they can't get somebody like me or Allison, who have so many people reaching out to us from prisons that take the time to write letters, begging us to look at their cases, swearing up and down that they're innocent. It's like hard. And then, like, again, everything's not murder. Like the amount of times that I've heard about people pleading out on cases where they'll pick up they'll be charged with a felony, and then the prosecution will turn around and say, look, we were going to give you 5 years on this thing, but if you plead to this misdemeanor, we'll give you 6 months in county. And even though that person has been swearing up and down that they're innocent, their lawyers who have been in the system long enough tell them what the reality is that, look, the government's got a hard on for you, and they've got some evidence, and they're going to come up with their theory, and they're going to try to sell it to a jury. And if the jury buys their theory, you're going in. So you get people pleading out to lesser crimes with the carrot of little or no jail time in comparison to what they're charged with. Innocent people that plead out guilty all the time, every single day. It's how our system works. It's how our system works. And again, remember, everything's not murder, guys. Oh my God. Yes, Carly. I did follow Jelani Day. I actually, when that thing broke, I was very, very much in that community. I was like in the Facebook groups. Like, if you guys don't know anything about the Jelani Day case, it took place down in Bloomington. Young black guy was going to school at Illinois State. I believe it was Illinois State. And one day just vanished. And, they're looking all around for him for days. It might have been weeks, because they finally find him in a river. And his body is, as you can imagine from wildlife and just being in the water, was me. I sound sad? No, I'm not sad. I'm fighting a little bit. I think Scout got a little cold. So I'm fighting a little bit of a throat. So I'm trying to be more like even keeled, so I'm not like hacking in her ears all day. I'm definitely not sad. But some of this stuff's heavy. Like there's time for laughter, and there's time for serious stuff, right? Like, you guys know me. When I'm talking about people losing their freedom, it's not a joke. So I'm definitely not sad. but thank you for caring enough to mention something. It's like I'm a human. Like some days are great, some days are meh. I did not test for COVID. I did not test for COVID. I don't necessarily feel sick, but I do have this like phlegm thing in my throat that's been kind of persistent and super annoying for a guy that uses his voice for a living. What is this? What is Allie talking about? It's fine. Turn yet? What is that English woman? What are you talking about? I'm like, are you done with court? You want to come hang with me? So I don't have to try to kill all the time alone, nobody to talk to, just a guy. Just a guy. I know you were on a Zoom, so I know you can do like just hop on, hang with me. Oh, let's see if she goes silent. But back to Jelani Day. And so they find the body. It's terribly deteriorated, and they like so much so that I don't believe, and the family of Jelani Day did not believe that they could accurately come up with a cause of death, because that ME down there declared that it was a suicide, which did not add up. Like it did not add up. His family was furious. It's a shame. I don't know if there's still movement on that, Carly, but yeah, I was very much wanting to get involved, especially because it's in my neck of the woods. Is anything still going on with it? I mean, like, has the family, or are they still pushing on it? It's like, they just didn't do an investigation. Like once the ME says it's suicide, the cops don't do shit. It's so sad. Like, and like, if I were to give you the facts of that case, I should probably do a live on that, where I give you guys kind of the facts, because they caught him on video going to a dispensary like the morning that he went missing. The kid was like, I think he was getting his master's in speech pathology. Like he was like a kid that was going places, like a kid that like had every reason in the world to live, that there was no indication of him being suicidal, and it didn't really add up to me. Oh, look at it. OG Missy Mayhem. Love you so much. 10 months OG. It's amazing. But yeah, Jelani Day is definitely a one of those cases that definitely caught my attention, Carly. And like I said, I was really, and that was another one of those communities where it was getting really heated in there. And in a case like that, where people, Amanda, that was interesting. Like, I don't know if you were with Jay and I when we watched that during the closings yesterday, but like before, because we went back and watched it after the fact. So, but so when he puts the picture up, I'm like, well, what about that hair? Like every time I see this photograph of the profile, it looks like a shadow profile. I'm like, it looks like that dude has hair. This dude's bald as shit. Like he's got a very distinctive profile. Like you see that bald ass head, like, I mean, he's like Mr. Clean. It would look like the shadow of Mr. Clean. So then when the defense stuck it up and then put the little graphic on their hair, I'm like, yeah, the hair. Oh, where are you going? To get me food? Awesome. I don't know where she's driving to. Hopefully to get me food. Oh, no, dude. Like they canceled school for Scout because, yeah, the air quality is brutal and it's like 100 million degrees out. It's like indigenous summer. Okay, wait a second. The pic of Tellez in the car yesterday was Tellez in a hoodie, not a hat. Okay. All right. Dizzy, can I put you to work right now? Can you try to find me those, whether it be from the live itself, the stream itself, or if we can, like, I'd like to be able to throw those pictures up to kind of look at them because those are clearly something that is resonating with the jury. I know that one of the questions was definitely about the video. Yeah, yeah, like yeah, Phil. No, so that's not my excuse for not but I'm not sad. I'm really not sad. I'm just, I'm just like I'm chill. I'm chilling. I'm chill. Like you guys know I act goofy when we're doing the trials. When I'm just sitting here chilling with you, I feel like I'm sitting on the couch with you all. You need me acting like a maniac all the time. Like sometimes we just want to chill and shoot the shit, right? That's what's happening right now. So, and again, Dizzy's got an eye on Richins. I've got, as you guys can see, and we are live on that. We've got the Tejas thing up, so we'll see. Cheap to pay. All right, I'm doing a. All right, it's time. I'm gonna pull this down for a second. Actually, no, I'm gonna do a poll. I'm gonna see where y'all are at. It's like that's an interesting concept to me. I'm curious as to whether or not you guys, like, we all went into this deliberation like hour, right? I mean, like, I think I made the comment that, like, if I do a poll and if this isn't the first like 100% guilty poll, that my head will explode, like some shit like that. So that being said, I'm going to do a poll because I want to see, I want to I was a sociology major in college. I found it a fascinating subject matter. But like I from the sociological, which is the macro level, and the psychological, which is the micro level, I want to see if the fact that the jury didn't see it the way that we see it, or at least one of them is a holdout, if that's caused any of us to kind of look at this case and be like, well, I mean, maybe. I look, and Jay and I said it yesterday. We really both thought the performance of the defense attorney was stalwart. I thought he did a great job with a really tough case with super bad facts. He did it without really having to delve into the whole conspiracy thing. Like he really was just poking holes, trying to create reasonable doubt. I thought he did a very effective job. I mean, that hair thing, but I thought Hamner who I call Schneidercuter, did an equally effective job in his closing. And I'm talking about the rebuttal closing. Like I thought that they both did enough to where I'm not shocked that the deliberations are lasting this long. You know what I mean? Like I thought that they both, like, because every single person deserves that. Every defendant deserves that. I mean, even in cases where it's just so evident, like, which we all thought this case was. All right, so I'm going to create a poll. I want to see where y'all are at. Okay. Okay, let's see. Now the question is, yeah, I think the concept, no way, is that like he had a hoodie up. Like he had a hoodie up, and that thing that we're seeing that looks like could be like a coif of hair is actually just like the hoodie. But I don't know. Can you see his face? Yeah, hopefully Dizzy's trying to like pull up the I'm assuming this is a yes from Dizzy, that she's once again doing my bidding. But like I want to look at this thing. I want to examine these two photographs. All right, so let me think. Because the wording of polls is very, very important, right? Because do you think he's guilty? I know it is just a silhouette, Pammy, but like, can you not make out a nose and like a chin? Because you can kind of make out that quaff or whatever that thing is that looks like it makes him look like he's got hair. I don't know. All right, so let me see. But like if we like ask a question like, I'm like, so and so, guilty or innocent? Well, if I don't articulate what I'm really trying to ask, which is not whether or not you think that that person's guilty or innocent, but whether or not the jury's going to come back. Those are two very different questions, right? Okay. All right. So this is what I'm going to do. This is what the question's going to be. Based on the evidence that we all saw, we watched the whole trial. Do you think that, all right, here's, now I want you to think about this before just immediately just hitting yes or no. Okay. Because like this thing is never going to be like a thing where it's like, oh yeah, he's actually innocent. Yeah, I believe that Compass Mortgage hired some hitman to do this. This is going to be, well, I'm not going to preface it. We'll converse about it after the poll results start coming in. And this is one that Allie's always talking about. All right. So don't just start like, take a second. Think about the question before you answer it. Oh my God. All right. Let's see. It's going to be exciting. Okay. We got 49 votes. So when I said take a second, that's it. Literally what you guys took was a second. All right. Okay. All right. I mean, we're up to 82 votes, 73, 84, 86. Mm. All right. Fair enough. Fair enough. Yeah. That's one of the bummers about the poll, right? You can't undo it, right? Yeah. I mean, I feel the same way. Like that amount of evidence, like the DNA under the fingernail, but I mean, it shows you, like, with that amount of evidence, and like, I just loved when Schneider Cuter was like, I don't know who said, like, somebody said it was a weak case. He's like, and he was like, weak case. Like it was something he said off the cuff, and it was like, right. But Amanda, let me give you some pushback on this. The cut up shoe and the hat. Okay. Let's just dig it. You know what I'm going to treat this like? Have you guys seen the old classic or even the remake of 12 Angry Men? Right? It's like open and shut case. Everybody comes back there. It's this kid who is accused of stabbing his father. Okay, and they live in an apartment tenement, and there's various witnesses. Right? There's a witness and there's a elevated train that runs in between the building in which he lives and across the street, the building that would be at the same level where, if you've ever lived in an apartment or in a city, you can see into your neighbor's building sometimes. So there's various witnesses that had all pointed the finger at this kid. And there's one holdout juror. I mean, it's been a minute, babe. Like, what time did they go back, y'all? Like, I don't even know. We were familying. All right, so we're at 182 votes. It's pretty, and I know that there is one inadvertent no, and it's a 91 to 9%. I mean, like if an election comes up, that's a landslide, right? But this isn't an election, right? This is a criminal trial. And that 91 to 9%, you know what that is that's like you got 11 jurors thinking guilty and one thinking not guilty. It's the equivalent to that. It's interesting. All right, so but getting back to 12 Angry Men, you know, so they all go in there. It's hot as hell in the jury room, no air conditioning, the fan's not working. Wait, what is Allie? Is Allie? What is she talking about in the chat? I can't. Why I see your face? What is going on here? I don't know. What is she talking about? Somebody tell me what she's talking about. Oh, how long has the jury? Like, where's the jury counter? I want to know. I don't know, like, what they are. How long are they in? They've got to be, because they went pretty late, right? Like early evening. Let's see. Let's see. Meg says, Bob, is it bad? That scares me. Putting my life for someone else. No, God, no. It's terrifying. Are you shitting me? It's like if you're a defendant, it's not only you're not only putting your lives in the hands of the jury, you're also putting in the hands of your attorney, because they're your mouthpiece. Except in this case, we know, Tellez took the shot. I mean, Tellez has to be very optimistic that this thing didn't. But like we all thought, like Tellez is Delulu. Like he's just sitting there. This guy's like has no clue that this thing is like a slam dunk. We're like all of us ripping on his like multitude of faces, his constant contortion of his face. Like we're like, this guy's what a schmuck. I mean, let's see. Let me see. I'm trying to keep up with the chat, y'all. Does anybody know how long the deliberations? Okay, thank you, your mom. 4 hours, yes. So 5 hours. 5 hours total. I mean, but like you can't read too much into that either. I once had a jury out on just a straight up DUI case that I decided my client wanted to go to trial, and I decided to bring it to a jury, and I had a very novel defense that it was defense of necessity, which is a very specific defense, basically saying that it was out of necessity that my client drove while he was intoxicated. And I ended up selecting a former prosecutor from that county that had left the prosecutor's office as one of the jurors. It was like such a dilemma for me to figure, like, I think Allie was there when I was picking the jury. I'm like, should I pull the trigger? But it's like, you never want to put a prosecutor on there. But it was such a novel defense that I thought that I had a good feeling that she would become the foreperson of the jury. And I thought that if I could get her on board with it, because it was a novel defense, but like there was truth to it. So at any rate, and even in that case, I think they deliberated 7 hours, and this was a case where like DUIs are essentially, if they've got your BAC, if you blew or they did a blood draw and you're done. Like, I mean, they've got the best evidence. And like, so to be able to get them to think that long about this defense that I presented was fulfilling. But ultimately, at the end of the day, they came back guilty. And of course, she was the foreperson. And of course, she was like, that theory's ridiculous. So she drove the guilty train. You live and you learn. You live and you learn. All right, so let's see. So we're at 236 votes, 92% to 8. I don't know. Oh, Cape Town, Africa. Nice. Nice. I love that. South Africa is like a country, just Africa in general is a country that I desperately want to travel to. I want all parts of it. I love traveling. Traveling's my favorite thing by far. I love Allie and I both love traveling. It's our favorite thing. Wait, three of the 8% out of 242 votes, 10% would be 24 votes. So PB and Shelly, fair. Yeah, I love getting to a different country. Yes, I know. I was talking specifically about the country within Africa of South Africa. But thank you for that. I was actually showing I was doing some geography with Scout this morning. Africa, that's a great country. You guys shut up. I was talking initially about South Africa, not the continent of Africa. But I was showing her that I was literally going through the continents. I was showing her North America, South America is what we're doing, the UK in less than 3 weeks now, or right around 3 weeks. And like, I'm like, are you doing any research on England and London, like where we're going to visit? Like, you're 12. You should be excited about this. This is like an amazing trip. So like, she's like, not really. So I pulled up the world map, all to tell you that I understand that Africa is, and I know that Africa is a continent. But thank you. I definitely did make a blunder. I'm gonna have to go back. Wait, 7? No, babe, you were speaking in absolute code today. I don't know what anything that you're typing is. Oh, I'm at Reams and cannot find anything to get. Ideas, babe. What do you mean, food wise? I'll tell you one thing you can get me is get me one of those stuffed the stuffed mushrooms, the big stuffed mushroom caps. Just get some kebabs or something. Like, get something. They have tons of oh, see, Allie voted no. Wow. See, that's what I was going to tell you. She's one of the ones. She almost never thinks the state meets her burden. No, I didn't teach her the wrong thing, Thug Nasty. The shame is that her primary school teachers have not taught her anything about geography at all. Yeah, no, somebody told me about an Insta account that I did follow yesterday who does some amazing things with the food scene out in London. So I did follow that account. So I want to know. I'm a foodie, but I'm the only one in the family that is. Allie's not a foodie. The girls, Cam and Scout, are definitely not foodies. Like pickies. That's what they are. Pickies, not foodies. All right. Okay, I'm gonna take a peek over here. All right, so Tejas is still chilling. Let me see what's going on. Okay. So this is upcoming. Let's see when they say this thing's about to roll. Yeah, they say Richins is supposed to start at noon. Nothing yet. Nothing popping. All right, I've now got this up. So checking this out. Like, they haven't even, like the chat's up, but that's it. Sounds like they got through a majority of that yesterday, right? That preliminary hearing. Sounds like the state's done. Sounds like it was left to the cross. What was you, CH? What'd you do? Are you guys are all telling me that you accidentally hit no? All right. So I'll I'll plus minus it at like 2, like either way, I'll give it like or even 3. It's still not it's still falling in that area, like where there could be one holdout juror back there. Or that guy who's forcing or gal that's forcing everybody to, really look at this thing. Like, look, I'm not just going to come in here and vote the guy guilty. We're going to go through the evidence. We're going to do our job, which is really their job, and I'm going to give you pushback. I'm going to devil's advocate and see what you think. Oh, thank you, CH. Yeah, I did. I followed it. It looks awesome. The guy's got a huge Insta following. For a guy that's like constantly cramming huge sandwiches into his pie hole, it's amazing. It's amazing what people like to watch. It's incredible. Sorry, y'all. All right. Kate, it's exactly for the. I mean, if you get diligent jurors, I mean, their job is to go back and to talk about it. It's like you really do want that. As much as I say, like, they'll be back short. I mean, they almost always take a couple hours. A couple of the things are weird. Like, I just find it. Wait, where's Rome? Where's Rome hanging out? I love Rome. Hey, Miss Jones. Welcome. Like, so I was really trying to figure out like what my Bears jersey was going to be, and I think I've landed on Rome Odunze. I think he's going to be a stud. Because everybody's going to have Caleb. Like, I always lean defense anyway in terms of my jersey selection. So, but all right, let's look at this. Some of the weird things. Somebody explained to me why this guy Tejas had the. It's true, T. Welcome. It's always good to see your smiling face. I've not been able to hang on one of your lives in so long, but I haven't been able to hang on any lives. Really. I popped in on one the other night. So I miss you, T. I miss you. Thanks for the hang. But the one thing that I was thinking about that bugs me about this case, all right? Like, I'm with y'all. I think this whole concept of this being something having to do with like Compass Mortgage or Compass Incorporated is nuts, right? Like, it doesn't add up. I mean, I could see a world in which, if like he was like, when I found out the amount that was at stake in terms of Compass Mortgage, that just made me think, nah, that's like $6 million, which to all of us is a fortune. To a massive corporation like that is a pittance, and they write it off as bad debt or whatever. Like, I mean, like they ain't sweating that. So like that kind of got me off of thinking, well, it's plausible, but so aside from that, zooming in on the video is not going to help the jury. Check your text, Bob. Okay. I'm looking. Okay. Yeah, it never gets any clearer than that, right? Diz, were you able to find the one from the other side? Oh shit, that's like worse than. That looks worse than like what they showed yesterday. I can't. Like, they showed one from each side. Let me see. Which one do you think is the best? Or are they all identical? All right, I'm gonna try to See what you guys think of this shit. All right, but to this other point that I was trying to make, explain to me, like I'm 3 years old or 5, whatever the case may be, why he would dispose of the knife and that jacket, but elected to keep the shoes, the hat, and the bag. Like why do that? Dude, Scott, that's what we're all with you here. That's it. Like, I mean, I don't know. Like, we're trying to figure out like what they're deliberating on back there. Like we were all like, this thing be back in an hour. They're gonna wait an hour just so it doesn't appear that they didn't deliberate at all, but they're gonna be back quick. And now we're 5 hours in. They spent the night on it, they slept on it, you know? I mean, y'all are preaching to the choir. We know the bad facts, yet here we are, 5 hours into a deliberation. Well, what's to explain is exactly what I said to you. Like pointing out the things that they do have. What I'm talking about is explain to me why this guy would get rid of the hat and the knife, but keep, or the knife and the jacket, but keep the hat, the sneakers, and the bag. All right, so let's see. Amanda's got a concept. I'm convinced he left the knife and the jacket in the garbage at the gym. Maybe he didn't have a change of shoes and didn't carry the large hat into the gym, Bob. Yeah, but I mean, like he was not arrested for what, 5 days after the homicide? Right? I mean, like this isn't like they're there the same day. So, well, yeah, exactly. Exactly, Elf. Like I find that to be super weird. And I mean, and the other thing is they didn't find Gurman's DNA on the shoes. The only DNA they found on the shoes are Tejas, right? I don't know. What? What are you, Meg? What? I'm allowed to give pushback. Does mean I'm crabby? No, I'm not. I am hungry though. I'm not gonna lie. Like I had a good dinner though, but I haven't eaten breakfast. So I was hoping Allie was going out to get us breakfast, and she's at the butcher, which is not an Allie place to be. She's not like a big meat person. It's like so, but here, like I want to flesh this out, and like anybody that puts anything interesting in the chat, I'm going to throw it up here. So, all right, so that was an interesting concept. All right, so he goes to the gym. You think he tosses that, the knife, the murder weapon, potentially still bloody, in a garbage can. Is this for Kouri? Oh, it's up. All right, let me pause it. Okay. Un momento, por favor. Un momento. All right. Hey, and just so y'all know, like I think dude's guilty as shit. Like I'm just devil advocating here. So I'm trying to figure out what they're going at. All right. So yeah, Richins is rocking and rolling. Let me pull that up. I hope, let's see if we get lucky and the sound doesn't blow. Because that was not us. That was definitely the sound in the courtroom sucked. So I had to crank the booster. Okay, get rid of the chatty poo. Go into full. All right. Okay. All right, so I'll rewind it to the beginning, kids. No fear, no fear.
The purchase of the $3 million Midway mansion where she discussed raising children and farming
Yesterday.
with him
Okay,
about a month earlier.
I guess what I'm saying is you don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for it.
Okay. So then I guess
The state has shown probable.
Oh shit.
Okay, but
about a month earlier. Financial motives.
All right, so we're at the very beginning.
Consider it in the course.
All right. Where's Dizzy? Get rid of that logo for me. Switch me over, Diz. Do something with that. Let me see if thank you. All right. All right, so y'all ready? This is the very beginning.
Should fully consider it. What happens before a charged event and what happens after a charged event is probative of the event, particularly in this case. Let me explain in some greater detail.
Sure.
I guess further to that point, Your Honor, to consider the attempted homicide in isolation or as a discrete event, I think would be an error. The best evidence of the attempted homicide by poisoning on Valentine's Day is the actual homicide by poisoning 17 days later. All of the defendant's motive that existed for the homicide also exists for the attempted homicide. And maybe let me just kind of detail some of that for the court. I don't want to belabor the briefing, but there's some highlights there.
I agree with you. The financial motives that existed in March existed in February.
That's correct. But
all right,
it's not
so
only the financial motive, Your Honor.
Let me try. All right, I'm going to try this booster.
And I don't want to recap it unless it's helpful for the court. I can recap the financial motives.
I think I have those sufficiently in hand.
Your Honor, the second motive that is just as present in February as it was in March, 17 days later, was her love interest in Mr. Grossman and their planning of the future. And specifically, the purchase of the $3 million Midway mansion where she discussed raising children and farming with him about a month earlier.
I guess what I'm saying is you don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for it.
Okay. So then I guess the takeaway, Your Honor, is that the same motive for the charged homicide it's identical to the attempted homicide.
I agree.
Okay, I will move on.
Yeah. And candidly, I think the state has probable cause that she procured fentanyl prior to February 14th. The state has shown probable cause that she wanted something stronger after February 14th and saw it again. Made a reference to the Michael Jackson stuff, which I think at least at the preliminary hearing stage, I can take judicial notice, refers to a well-known event in which someone took a controlled substance and died. I'm tracking all of that. Where I stumble or where I pause is, do we have an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
So we do, Your Honor. Let's
or attempted to do so.
Sure. Let's kind of focus.
So this judge, if you guys have not, he's great. And I could not love this question more, and I'm going to actually rewind it because I want you guys to watch this again. So again, preliminary hearing, much lower standard. It's a standard of probable cause in order to bind that the court finds it that the crime that there's a high likely a reasonable expectation that the crime was committed, and it's a reasonable inference to believe that the person, the defendant, is the one who committed it. So it's a very low burden. but this question is that he's putting it to the state to ask directly whether or not they have any kind of evidence that she actually poisoned him. So, like, I want to hear him ask it again because it's interesting.
Fentanyl prior to February 14th. State has shown probable cause that she wanted something stronger after February 14th and sought it again. Made a reference to the Michael Jackson stuff, which I think at least in the preliminary hearing stage, I can take judicial notice, refers to a well-known event in which someone took a controlled substance and died. I'm tracking all of that. Where I stumble or where I pause is, do we have an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
So we do, Your Honor.
This is relating to the most recent
Let's-
attempted murder charge,
Or
by the
intended
way.
to do so?
Sure. Let's kind of focus in then on February 14th with the understanding that she 2 days earlier, the probable cause understanding that she 2 days earlier purchased fentanyl from
Sure.
Ms. Lawler.
Got it.
Okay. So her conduct on Valentine's Day helps establish that she, in fact, provided the fentanyl to Eric Richins. And so her conduct that day starts early in the morning when she purchased a sandwich from the Mirror Lake Diner.
Well, we know she makes a purchase from the Mirror Lake Diner, right?
Yes.
We don't know that it's a sandwich based upon admissible evidence.
So we do.
Tell me how.
The invoice from the Mirror Lake Diner entered into evidence as Exhibit 66.
Go ahead.
Shows I think it's labeled on the invoice as breakfast sandwich.
Yeah, bagel sandwich.
Okay,
Got
bagel
it.
sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Remind me, which exhibit is that? We're gonna need to talk about
I'm
that in
gonna
some
need
detail.
need
Yeah.
some help on that.
I know what you refer to, but I just need to look at it with you.
Yeah, I might have it in my notes, Your Honor. If not, we're working on that
Okay.
on the side.
But keep going, we can go chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning from the Mirror Lake Diner. We also have, as the court's seen, bank statements that confirm a purchase, phone call that confirms an order. The receipt corroborates, the invoice corroborates that the phone call is related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner. I think it's something like a 907 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is a text message with her best friend.
Okay.
We then know at 9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of leaving the campus area with an arrival time at some unknown destination approximately an hour from then. We also know.
All right. So is my mic deafening? Is it too loud, y'all? Because I didn't lower the volume on that. If you're late to the party, We are keeping an eye on Tellez. No verdict. The jury is still deliberating. We are currently watching the second day of the preliminary hearing in the Kouri Richins case. If you don't know anything about that case, it's a tragic, fascinating case. Mother of three stands accused of giving her husband, Eric Richins, the victim, a lethal dose of fentanyl. They recently charged her, which is what they're actually talking about right here, which is that she attempted this one time earlier. And this was on, I believe, Valentine's Day, where she went out. The state's theory is that she went out, bought the meat in order to make his favorite sandwich. 2 days prior to that, had met with a known source of drugs in the area, purchased a bunch of fentanyl pills, and the state is asking the court to make the logical leap that the story from Eric Richens' text messages state that basically after he takes one bite of the sandwich, he immediately starts feeling like he's dying, like he's ill. Goes and lays down, takes a 2-hour nap, doesn't die, gets up, texts with both of his friends, two of his closest homies, and is like, dude, like I just, like, you're talking to a guy who literally almost just died. Equally disturbing is the fact that right after he started feeling that way, and again on Valentine's Day, he tells his wife, who had left the sandwich with a note on the seat in his truck, hadn't even come into the house, claiming she was running around doing all the things. She had a business wherein she was buying properties and flipping them. Okay. And they were, so she ends up never coming back that day, including after he texts her that I feel like I need to go to the hospital. So she, not only does she not come home, she doesn't even text him to be like, what? Like, are you okay? It's always a sandwich or sandwiches, depending on my mood. I'm trying not to mention it, Meg, because I'm starving. So, like, the more I talk about a delicious sandwich, the hungrier it'll make me. And the hungrier I get, the angrier I get. And no one wants that. So I'm not talking about. So that's kind of where we're at with this thing. So what this thing is, a preliminary hearing, again, I say what the standard is, what the burden that the state has to meet. It's a probable cause burden. It's very low. But it's for all of the charges, including the most recent one, which is the one that they're talking about right now, which is, and the judge gave some pushback. He's like, okay, I know that we have her purchasing the drugs 2 days prior. I know we have her purchasing the makings for the sandwich. And what kind of evidence do we have that she actually poisoned the sandwich and that it was the sandwich, in fact, that is what poisoned him? So that's kind of where we're at with this. And so this is the state. I believe his name's Bloodworth. And he is currently giving a spiel to the court.
Based on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richins, with her paramour. Eric Richins has some medical event strong enough that he texts the defendant and says he's considering going to the hospital. We have that text exchange in evidence.
Right.
Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with no activity on his phone and associated devices. All of that is consistent with reaction to fentanyl.
I've read it, but I can't remember the number. The number 4, the 1102 from the person that lays that foundation regarding a reaction to fentanyl.
Yes, so that's the toxicologist, not Slauson.
Okay, thank you. Keep going.
Your Honor, also in evidence is literature from the Mayo Clinic, which lays a similar foundation. Okay, so we now have, right, in the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richins is sick enough that he's considering going to the hospital, and he's inactive for 2 hours. All of that consistent with fentanyl poisoning. And then at that point, the defendant's own words are kind of important here because he texts her, right, of his illness, of considering going to the hospital. And what she says is chilling. She says, take a nap. And then she doesn't check on him for 2 hours. She doesn't come home. She doesn't text. She doesn't call. She doesn't check on him. Their next communication is 2 hours later when Eric Richins checks in with the defendant.
All right, so Diz, I think he only slept a couple of hours. I don't think he slept a day and a half. That would be. So I think he sleeps a couple of hours, wakes up and feels better, reaches out to her. I think it's within a couple hours because that was the entire when we were going through the excited utterance and like the temporal time aspect of it, like how close in time does it need to be in order for it to still be an excited utterance, which is a hearsay exception. So I think I don't think it was a day and a half. I think it was 2 hours, I think. Oh yeah, for sure. Like it's a super low burden. It's probable cause. It's a super low burden. I think I like that the judge giving the pushback on this particular occasion because like he survived this. And what we're hearing the state say, because he didn't go to the hospital, I don't know that the state is going to be able to prove that on the 14th it was fentanyl poisoning, okay? As opposed to maybe it was bad meat. You know, whatever the case may be, you know, we have that link between she's purchased the fentanyl 2 days before this, and then she goes back telling the dealer, I need something stronger. I need a stronger dose of the fentanyl. The second time that she purchased fentanyl, which leads to the death of Eric Richins, obviously, after he's deceased, they then, when they're performing the autopsy, they're able to establish that that was the cause of death, was fentanyl poisoning. So again, remember, we're talking about two different periods, two completely different charges. So the one that they're discussing now is the first in the state's version, the state's first attempt by her to kill her husband.
Notably, Throughout the day, Valentine's Day, and thereafter, the defendant's reaction to Valentine's Day events is consistent with a consciousness of guilt. She had texted on February 11th and 12th significantly with her drug dealer during a time frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and the Draper.
Right.
Those texts are deleted from her phone. She texted with the drug dealer 30 times, about 30 times with Mr. Kouri-Dimos' testimony. On Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times. Eric Richins texted the defendant a photo while he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone and also from Eric Richins' phone. That is in the moment consciousness of guilt. The next day,
Forgive me, I don't recall testimony from Mr. Kouri-Dimos or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but
very young.
okay.
The next day,
Did you see Kouri Richins with the Tayaz style furrow brow? It's like, what? Consciousness of guilt. This guy. Yeah, if you guys don't know anything about this case, it's crazy. Just another little tidbit. So yes, three young sons at the time that Eric is dies. And obviously super, super hard on the children. And exactly so she goes ahead and writes a children's book entitled Are You Here With Me? That she gets published. And she wrote it, she's saying, in order to help her own children get through the grieving process. And she does a little book tour. There's the infamous, it's like Utah Today morning show she goes on where they're talking about it. And the motive here is money. So I know they keep talking about the paramour, but the states never kind of really leaned into that she's trying to get rid of her husband because she wants to be with her paramour. The motive here in the state's estimation is money. Eric had done very well in his own business, but beyond that, I think there were multiple life insurance policies, and there was a trust that he had created because I think he was iffy about her, and Kouri did not know that he had not made her the beneficiary of the trust. And not only that Kouri was not the trustee. Like she wasn't going to be running the trust. His sister, Eric's sister, was. So that was a shocking surprise to her, which she did not find out about until after Eric dies. Okay. Like this, and like I was saying, like when Allie and I really start digging into this case, I have all of the probate pleadings in this case. And the probate, much like in civil cases, like where you have like Karen Reed, they just sued the Waterfall and whatever the other bar is and her. When you have civil cases, you have depositions, and in depositions, you get all the tea. You get to add, there's nothing that you can't ask in depths. So here in the probate, this is like you get in these pleadings, it's where you get all the tea about all the bad blood and what Eric's family thinks about her. You know, it's a lot, but it's really an interesting case. So I'm glad they're streaming it.
After Valentine's Day, February the 15th, 2022. The defendant lamented to her paramour, if he could just go away, life would be so perfect. And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Eric Richins was dead. We've referenced the
I mean, that's powerful evidence. That is circumstantial, but powerful as shit.
Exhibit 8, the text messages that the defendant sent to her best friend.
I don't think that's 8. I think Celebrite is 8. Can you give me that number?
Well, Your Honor, it would be found in the Celebrite extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot, it looks
Oh,
like
okay.
that.
Let's get there together. I need the exact language of that. It would be. Okay, got it. So this is, we got to be specific about this, a June 18, 2022 communication, correct?
yes, Your Honor, it's
Okay.
June 18, 2022. I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation kind of is wrapped up in the attempted homicide charge that was made in the civil litigation. And timing would suggest, I think it is reasonable to infer that they were discussing this text is a discussion of the Valentine's Day 2022 incident as put forth publicly in civil filing.
I have some questions about this when you're done going through the evidence.
Okay.
I also have questions about the February 15 text messages, so just put 2 pins in those. I'm not questioning the existence, I didn't know how much it exists.
No, sure. So I that glance was to get a copy of whatever the
Okay.
February 15th text was.
Well, see, if you would just go away, and then
Yeah.
I promise we'll be together on Friday or worse than February.
Yeah, yes, Your Honor.
Okay.
We can discuss those kind of texts when we're both looking at them.
Okay.
The text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages with Eric himself. We know that to be false from her text messages with her paramour. We know that to be false from the navigation screenshot. Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him. The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen because she knows those facts are indeed true and indeed inculpatory. So do you want to discuss this text, or should I continue on with kind of further answering your question? Is how the homicide charge kind of relates directly to the attempted homicide charge?
Well, let's pause here for a second.
Yes.
Me too. It's not that bad for me though. Like I can hear him fine.
We also skipped over.
Not Chris.
Or didn't mention in that recitation. Remind me of the date where she asks CL for something stronger.
So, Your Honor, that I don't know that I know a precise date. It's somewhere around February 25th.
I think it was 12 days later, right? Okay.
And Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide by poisoning is the actual homicide by poisoning 17 days.
Just sitting there.
Hey, babe.
Hi, my stuff's not working.
What do you mean?
Did you switch them?
No.
Mm.
The headphones, no.
Hmm.
I found my beautiful blue headphones on the floor yesterday.
It wasn't
not-
me.
Oh. Who was it?
Mm-hmm.
Was it my dad? Should I blame my dad? I'll say, Dad, did you come over and throw my blue headphones on the floor? It was you, babe. It was you. I know it was you, Fredo. You broke my heart. Can you hear in your headphones?
No, I was just commenting that the judge seems to be like paying a lot of attention.
He's a very good judge.
Well, but if this is, you said a preliminary hearing,
Yeah.
he seems to be actually caring, like as though it's not a foregone conclusion.
Like I said, he's a very good judge. You want judges to care. Even
Well,
though it's
yeah.
a low burden, usually it's a rubber stamp. He doesn't treat anything like that. He's a good judge. And everything that I've seen him doing, he's a good one. He's a good one. See, like I imagine this is what you'd be like on the bench. Right?
Nope.
Oh, just rubber
Yes.
stamp city. Rubber
No.
stamp city.
The defendant learned from the attempt and applied it to the homicide.
Use more
And we
drugs.
see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day wasn't strong enough, which is why she went back and asked for something stronger. But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer fentanyl. That is the same. The drug is the same. The drug dealer is the same. The timing is the same. But she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich where Eric Richins could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richins would throw it back all at once. She says that in her journal article, her journal note at exhibit
Wow.
49. and she learns that it takes a truckload of fentanyl to kill him. She
What?
learns that
I
one
don't
bite in this
understand. We're here.
punch is
People die
enough.
left and right with a little bit in their
It has to be
coke.
stronger, it has to be administered at once, and it has to be a lot.
Is that her?
That's why Eric Richens' toxicology
She's in the blue.
shows 5 times the lethal
See, you can never tell a
amount of blood
killer.
and 20,000 nanograms per milliliter remaining in his gastric fluid.
Today is the first day of
And the
last year.
homicide are
Whoa.
MO and lessons learned.
If we view, let's imagine for a moment that everything through February 15, well, February 26 stays the same. Imagine Eric Richins is still alive. The text message on June 18 gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
We would, Your Honor, and I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
Right. And I hear you telling me it's a non-speculative inference that you tried to poison him because we have her admitting that you ordered lunch from Miracle Diner. We have him having a significant enough event that he contemplates going to the hospital. We have text messages.
Judge isn't buying it.
That draw reasonable inference that she wanted him dead. We have her out looking for something stronger when he did not die on February 14th. We have a financial motive. We have the medical foundation. The difficulty is, right? And
He
maybe
sees
this just
difficulty.
highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Nestor and Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge if the spouse has
Oh,
around the same time. But here you'd say,
And the spouse dies 17 days later under very, very similar circumstances.
wait, 7.
And that no connection between the two.
Man, he's giving him pushback on this.
Yeah. He's like,
It's-
you're lucky. The burden's so damn low.
right.
I missed what his issues were. My phone, it's like the sound is coming out, but
Meg P, $20 Venmo. Thank you so much. Money towards a sandwich or DoorDash money. Wink. Thanks, Meg. Love you. You're the best. Always give her.
404 that lets me connect the dots here.
I don't even think the court has to go to 404. I think the
Do you want to explain to the kids what 404 is?
other bad acts or evidence.
court can connect.
So that would be that uncharged crimes, other bad acts. He's trying to say it's motive or plan.
Oh my God. I didn't even see this. Ashley,
That's why I left it up there because I didn't say anything.
today is the first day of my last year of law school. 3L. Woo. Boy, Allie and I, by 3L, we were over it. We're like, yeah, should we go to class there? Should we go see a movie?
Everybody else was like looking for jobs and interning and
Yeah, we're going to watch movies. We're like, yeah, seems like a good matinee day. Lurking Crew. I'll be on the rewatch Lurking Crew, so Bob and Allie and chat can help me keep my sanity. We love you, Ashley. Congratulations.
Yeah.
Power through this last year. You're gonna be like, I'm ready to take the bar. I'm ready. But just
yes, love.
power through. And then we'll be there for you when you're studying for that bar. Because that's intense. Studying for the bar for, I don't know, what do we study? 6-7 months for that thing? Like just all summer, like all day. It was a lot. It was a lot. Well, we're proud.
I got to
of you.
go pick up Scarlett in the subdivision because it's too hot.
Okay. All righty. All right. Congrats, Ashley, and thank you for the $10 holla. We're proud of you, and we appreciate you, and we're excited for you. And I think when you pass the bar, I think I'm gonna have you come on for a live if you're up for it. Tell us all about your future career. Hopefully you're keeping a criminal defense attorney in play. We'll see. We'll see. No pressure. No pressure. All right, let's go.
So, yeah, something that's relevant. I guess the court could connect the dots through probative, but there's no doubt, especially, returning to the fact that this is a domestic violence case. The court sees the consistency in the domestic violence defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
It's equally present. It's separated by merely 3 weeks.
correct.
Yeah.
It's equally as strong. Now, Your Honor, the court raised, this isn't speculative, and it's not. And Schmidt kind of talks to the notion.
Love that.
Right, that the court's job here is not to sift through the evidence and find the most reasonable explanation, just to make sure that the state's record, that the most reasonable inferences, just to make sure rather that the state's inference is reasonable. And we leave the most reasonable inference question to the jury.
It's got a little Jack Nicholson in him.
All right, so if you've got probable cause for count 2, you've got it for count 4.
Yes, sir, I think two goes that, or 4 goes that, 2 goes.
Right. I think I understand the state's position here. You will, of course, get the last word on counts, on all the counts, but certainly counts 2 and 4. I have some questions regarding some of those financial counts.
Yes.
Bear with me for a moment. All right, count 8 for insurance fraud. What is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy. I'm following the state's argument. I'm not sure what count 8 refers to.
Yes, Your Honor, and in the statute under count 8, the insurance fraud statute has different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
Well, for count 7, right, it's either it could be the forged signature, it could be the false representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there. Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count
Sure.
regarding the false signature, I think, in either, bear with me, 9 or 10, or maybe 11. Candidly, I think 11 is for a forged signature on the $100,000 policy.
Sure.
So
That relates to the claim, right? Count 7 is a false claim
right.
on an insurance policy. Count 8 is a scheme devised to get the money falsely from an insurance company.
But
Can or cannot involve a claim.
fair enough, but is it I acknowledge that we don't need to get into merger today, but
Sure.
is it the forged signature on the $100,000 true stage?
Sure. It's the signed application on January 28th and 29th. It starts with the application
Okay,
for the policy that issued on February 4th.
right.
10 days before the attempted homicide,
Okay.
a month before the homicide. It starts with that signed kind of application that the court will recall there was no way for the insurance company to contact Eric Richins right? They can only contact the defendant, right? The defendant used her business PO box. The defendant used her email. The defendant provided an improper phone number.
Okay,
And so that submitting that application begins the scheme.
got it.
And the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted into evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is I'm going to submit a false application for insurance on Richens' life. I'm going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is allegations regarding Eric Richins' signature on the application for the $100,000 true stage policy.
Correct, Your Honor. That's the policy in Exhibit 17.
What is 9 and 10?
9 is the fraudulent bank statement that the defendant provided to Iron Bridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang. That's the cut. Those are the cut and paste job
Got it.
statements.
And so the forgery count of 9 is related to the mortgage fraud count that is in 5, right? And then the forgery count 10 is related to the mortgage fraud count in 6.
Correct.
Got it. Okay. Thank you. Anything else you want to put on the record at this time?
No, Your Honor. I'll be back.
Very good. Ms. Lewis, how are you?
I'm fine, thank you. I'm going to address really just counts 1 and 3, and a little bit of 4. And then Ms. Nestor is going to address count 2
Okay.
and the remaining counts.
Tell me where you see the gap on count 1.
All right, well, here's where I see the gap. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of an interesting situation because the burden of proof has to be at the preliminary hearing, and the court does need to make a new finding at this hearing. And I actually think, interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief as to the first element of aggravated murder, that she actually intended and knowingly killed Mr. Richens. Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lauber. Well, what that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richens. She doesn't know what she gave Ms. Richens. Whatever she gave Ms. Richens has been through at least 3 people before it came to Ms. Richens. Ms. Lauber got it from somebody, Mr. Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we don't know what was given to Ms. Richens.
I don't disagree that we don't know, but knowing is not the legal standard that I'm required to apply today. So tell me why Ms. Lauber's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law that the stuff that she provided was fentanyl.
Well, let's look at the distribution counts and examine that.
Yeah, we can't do it. All right, go ahead.
So looking at the distribution, then I'll backtrack a little. So Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with insane narcotics, but with controlled substances, is consistent with street fentanyl.
What he said.
Okay, there you go.
Anyway, I was trying to remember if this was in the record or not before I said it out loud. So that's what was my pause there. But I have never seen a distribution case where there actually don't have anything that was distributed.
You mean a preliminary hearing or a trial? Two very different universes.
Well, personally, neither. Okay. Personally, I've not seen it either place. But I don't think just an individual who's a drug addict saying, I thought I gave fentanyl. I mean,
Doesn't that form the reasonable belief, though? I mean, by all accounts, Carter Lawler knows the difference between a controlled substance and not.
well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some experience with it.
Detective O'Driscoll testified that she said initially, and she said it in more than once, that she knew nothing about fentanyl. She didn't deal fentanyl. It's not her drug. And he said that.
These are great trial arguments, but I question whether this would be sufficient to these concerns are sufficient to rule that there's only a speculative basis rather than a reasonable basis.
And I understand.
There was provision of a controlled substance.
I mean, I understand your position, where you're headed with this, but I do think we want to, for the record especially, Detective O'Driscoll testified that he could not say with any certainty
Sure.
what happened in those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl. What happened to them after February 25th? I mean, the third ones were allegedly received after
Right.
Mr. Richens' death, which is interesting, in terms of what these pills were actually for. And I think, and again, maybe a trial argument, it's interesting.
Yeah, I've seen a few people ask about the paramour that they keep discussing. So she was allegedly, am I very loud? I had asked. I don't know if they typically do record like panels with the crime con. So I'm not sure though. I don't know if he was having an affair as well, does he? But like the guy, he was a handyman. Remember, she was in the business of flipping houses. She would buy a house, fix it up and then flip it. And this guy, Robert Grossman, was her handyman that was doing the work at all the houses. And the state's alleging that they were in a torrid affair, and that they were hanging around all the time. But, that's going to have to be something that's like, I think that's why the state's not really leaning into that as being the motive. I think the financial gain is the motive for them because, obviously if you have a situation where she's flipping houses and this guy's the handyman that's doing all the work, she's going to be spending a lot of time with him. So, it's explainable. It's explainable. Now, of course, the phone data will tell the tale to the nature and extent of that relationship, right? But I haven't seen that yet, so I don't know if they've brought that out in terms of proving that they were in a sexual relationship. Right? Yeah. Then she evicted him from one of the houses that he was staying in, and he was walking around the streets of Utah homeless, the paramour. So just a little more background.
That was the purpose of these pills, that they were still being handed out afterwards.
Oh,
But he said he could not testify
shit.
what happened to those pills. He
All
cannot
right.
testify what was in those pills. And he does not know how, if those pills were given.
All right. I definitely want to watch this jury question. So we'll flip back and forth. I warned y'all today was going to be, we're doing double duty here. I definitely want to hear this question, the jury question. So are they back in there? Does anybody know? Are they back in the court? Let me see if I can pull that up. I want to see what's up with that. Don't want to miss that. Wow, another question. Another question. Oh, shit. All right. So I've got that up. They are not in court yet. So I will keep an eye on this as soon as the defendant's not even at the table, nor is his lawyer. So let's keep going with this. And when the whole crew gets in there, we'll switch over to Tejas.
To Mr. Richins, and if they were, how they were given, who gave them, did he take them himself? There isn't
Thank
any
you, Des.
evidence as to that. And I understand, the position and the very low standard we're looking at here. Again, but that would be.
To be clear, the court's position is based on an application of the standard, not because I have an
I
independent belief
understand.
of what did or
And I
didn't
didn't
happen.
mean to imply that
Right.
it was your personal belief. I understand the standard.
Right.
And your application of the standard. Our position is still that there needs to be something more. When you look at everything that's been presented as evidence in this case up to this point. And particularly on the distribution count, I think it's,
3 or 4.
well, to both, but there's additional, of course, problems with the February 14th
Right.
distribution.
With if there is evidence sufficient to support a reasonable belief that Carter Richens put some drugs in a drink and handed it to Eric Richens, there's probable cause for the count 3, right?
Yes,
Okay. All right.
you're right. But I think I've made my argument on that, and I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Carrington's testimony. I understand that, but nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
The motive would provide some foundation for intentionally or knowingly. Let me put it differently. If there was no motive, their inference would be harder to draw, correct?
Yeah, you're
Okay.
I think that covers what I have in our record on that. I don't know if you have any other questions, but Ms. Nestor will talk about counts 2, and then that, of course, relates directly to count 4.
Elf, yeah, we're on it. We're on it.
Okay. I think I understand your position on 1 through.
Okay,
Thank you.
thank you.
All right, just so y'all know, I have it up too. Dizzy's keeping a close eye on it. Defense lawyers are both in the courtroom.
I think the only thing she got wrong was breakfast for lunch.
Well, I think her location about her being home all day is one of the things they need. We were working from home that day.
I mean, that's easily provable. So it's not like when she's talking to her friend, she's trying to remember the day back, a few months later. And she got part of it right. I mean, and part of it wrong. And I just don't know if it's just, how do we know that? What purpose would that be? How would that serve as a lie?
The argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie. Because you're with your boyfriend. And you don't want to admit you're with your boyfriend.
Right.
I mean, that's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
Okay. That's one credible inference, right?
Yes.
All right. Would you say that?
But that's an argument for trial. Carol, I turned it down. Hopefully it's better. I've got it cranked on the booster because the sound stinks at the hearing here. But that's not an issue for preliminary hearing. That's an argument you make at trial, right? That's not what the evaluation is here.
That's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present when
She admitted she was present with him, and she was. She brought him breakfast. So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. That's a statement against interest.
Okay.
In my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on the fraud type arguments, I do think that the state never established jurisdiction or venue for any of those counts. I don't believe we've heard any proof about why this court has jurisdiction over these acts. They did not establish where they occurred.
why isn't there a reasonable inference that Kouri Richins was making these applications and forming these schemes from Sun and Kim?
And they have to show that. You can't just out of whole cloth make that up.
Okay, we're going to pause this right now. I'm going to stop sharing that. I'm going to go over here. We are going to go to the Tellez jury question because we need to hear it. I want to hear it. Definitely want to hear it. Okay, let's get it up. The nice thing about this is they don't have horrible sound as well. But yeah, I think it is moderately better today. So there's no sound yet, but we'll keep that up. So I wish Allie would come back with me. So I can just tell you from the years of trying cases and from the defense attorney's perspective, you love hearing that the jury has questions. Love it. And, you know, there's always that debate. Oh, good. There she
They have a
is.
question.
They've had multiple questions.
I need to know about all these questions. I don't
know,
understand what
asking people
happened
to
that
tell us what the
caused
questions are, and
it
no one was
to
able
be
to tell me what the
questions.
questions were.
Oh, you didn't see it either?
I was at a volleyball game with you and our daughter playing, so I missed like the question. Like we were out when deliberation started. So one of the
I
questions
do remember.
know,
Go ahead.
was that they wanted to know if they could zoom in on the video. So there's the video.
That's what I asked you. I was like, why can't they do it like Froop?
Right. Well, because the defense made the argument that the silhouette that you see of the individual in the Tahoe that's caught on film, that it appears very much like he has hair.
Yeah, I thought that when we were talking about it the first time we were on it.
It looks like this dude's coif right there. That's exactly what the hair looks like from the side view. Allie is loud since you turned yourself down, Bob, for Richins. She says, so turn down your gain a little bit, babe.
All the way to the.
Yeah. Hold on. I'm going to go in here real quick.
I think I'm talking loud too because I can't
Wait.
hear myself.
Let me share it again, but I want to, hold on. I want to make sure that the booster's down because it's going to be so booster's good here.
They're saying they can't hear you, babe.
I know. Like you guys, I have to mess with sound. So like our mics are they're in a different place than the court. I realize that I'm working on it, doing the best I can.
Are you working on it at least?
Yes, honey. All right, so
maybe you should work on it.
I'm going to try to work on it. Okay, so we got this back up. Okay, Tellez is in. All right, is Allie good? There's no sound for this yet. They don't turn the mic on until the judge is back on the bench.
They're saying fine.
Okay. but I can like I cranked mine way down because I knew I had it cranked way up for the testing. I
That
usually have it right around
that
here,
was
60.
that was a little bit better.
60, that's where I typically have it. Is that good?
Yeah.
Yeah, because when we use the booster, it also boosts our mics, which I'm always afraid I'm going to blow your eardrums out. Or when the ads come on, that those will really blow your eardrums out. So I crank my mic way down. But for this, the sound's normal, so I could keep it at normal. I did get food.
Defense went first.
So I was just starting to discuss how we view questions. We love questions, typically. I mean, if they're
Everybody loves a question.
everybody, well, I don't know that the state loves questions.
Well, but at least it gives them an idea.
Yeah, but the state wants quick verdicts. They want, hey, yeah, you nailed it, guilty.
Right. Yeah.
Yeah, Joni, I know the ad. It's just like regular commercials on TV. Like, they have those jacked up to like some insane
Hey,
volume
your
level.
plot worked.
What plot?
Joni's comment.
Oh, yeah.
Hey, did you tell everybody how you went to see Houseplant and I didn't?
No. Actually, I did. I did
You
tell
did.
him. I did not tell him to go follow our friend's YouTube channel. They're trying to
Well,
break 1,000 for the band, and they're a great up and
what is it?
coming
Because
band.
I haven't done it yet. And you said it's not just Houseplant.
Let's see.
Houseplant music.
No, he sent it to me. Tavis sent it to me.
Yeah, all I see are houseplants.
Yeah.
Oh, here's one. It says Houseplant Whirling Tiger Louisville. Oh, it is just Houseplant. Why doesn't it come up when you do it?
That noise threw me off. I thought that was the court. I'm like, oh no, they're
Oh,
volume
wait. I didn't
too.
subscribe. I liked. Subscribe.
All right, but enough of that. I'll put that in the link. So, like, but with questions.
No, I was talking to myself. Like I clicked the right button. Not.
No, I know, but like, I want to like jury questions. Like, typically, we want, like, we never know if like a quick verdict is good for us or not. Like, I mean, there's differing opinions. If the jury comes back quick, is that good for the defense? Is it good for the state? I typically think that longer.
Yeah.
I guess if I had to pick, like, I want like the middle. Like, I don't want too long, because that's always like in my mind that somebody's trying to convince somebody one way or another. I like the middle, where I know that they've spent some time deliberating.
Yeah. I mean, so, I'm always of the mindset, the longer they go, the better for the defense. So where do we think that starts dropping off? That it just switches. That now you're worried about
Wait,
maybe
you're talking through it.
well, because we're saying like typically it's like, well, the longer they're deliberating, the better
Wait,
for
you're
the
talking through the
defense.
questions.
Right. But what I'm saying is you're saying there comes a time. Oh, we're talking through the questions?
You are talking through the question.
Oh, I don't hear anything. I don't know if anyone else hears anything.
Do you guys hear this? What the hell?
Yeah, none of us. So good thing I was talking through the questions, so you knew that none of us hear anything.
All right, so no one could hear that?
Nope.
No one could hear those questions.
They're all saying no.
Okay. All right, no wonder you were like, I'm like, you're talking through I could hear it, like backstage. But let me see.
Figure your shit out,
say.
man. Right,
Yeah.
Leslie?
Let me see. Like, I've got it on 2 different places for some reason.
That seems to always be your
I'm gonna
problem.
shut that one down. Yeah. Well, it's hard because I've got a lot of I'm trying to do a lot of shit here.
Mm-hmm.
Uh-huh.
I feel like my microphone is loud, but I can't Where is this coming from? You're really keeping us all in.
It's all right. Everybody will be fine.
I don't know if we'll survive.
What the hell? All right.
I'm gonna go check out a house
probably-
plant then.
Okay.
I think this is the
All right.
show you went to me without me last time.
It is. I'm a better friend, obviously. All right. I think I got it figured out. Sorry, y'all. Yeah, I was like, why is Allie just like talking through the questions?
Good thing I was talking.
All right, let's see. Okay, so I'm gonna bloop us till we get to bloop, 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 bloop. All right. Now tell me all right away if y'all can hear it.
Attorneys on both sides, Mr.
You can
Teller.
hear it.
I got a note from the jury. It's been marked as court's exhibit number 25. Has a few questions. It says, can we get another laptop to review the digital evidence? So I'm assuming they want a second one. And so we have it? Okay, so I'm assuming there's no objection to the court having the court officer take back a second laptop. Okay. Then the next few questions are, the first one is, can we get the side-by-side walk comparison video from the closing statement?
Whose was
The
it?
closing statement is not evidence. Then the next question is, could we get the exhibit number for the Jeff Gehrman news article videos about Mr. Tellis? I believe that's in evidence.
It is in evidence. It's
Who's-
it's the lowest number of flash drives.
I just want the parties to agree before I
Oh, okay.
answer.
I'm not positive, but that's what I think is on the lowest number. Of course,
Do you know who
Yeah.
displayed
No,
that?
I don't.
she's gonna say flash drive.
You were with me at a volleyball game. Chat. Whose exhibit were they asking about? Was it the defense that put up the side by
Whoever
side?
says it was in the state's rebuttal. The state
All right.
didn't talk.
The state likes that then. If that's what they're looking at, I don't think it's as like, I don't know. So what does anyone think, whether it be you, babe, or the rest of the chat, are the points that the defense made that is resulting in this? Because I don't know anything. All I saw was his testimony and whatever else I popped in for.
Miss
Miss
Jones
Jones, oh, you are
has an
correct.
interesting question. No, but it doesn't matter that they used, like, the argument is not evidence. The fact that they use pieces that are in evidence during their argument, those exhibits that are entered into evidence are evidence. So they can, of course,
No. That was two different things because the judge definitely made it seem like he did a demonstrative for closing, not that maybe they weren't both exhibits. But how could he have done that if they were?
well, no, I think what he did in terms of so the pictures of the Denali are in evidence. They can definitely look at those. Let's just get
Right.
that straight. What he did do during the closing is he made an arrow and wrote the word hair. The defense did. So they won't be able to use that one, but they can certainly use the exhibit that was just of the same picture minus the graphic saying hair. As far as anything that they prepared exclusively for closings, yeah, that are like, if they're videos or what have you, they won't be able to use anything like that. Well, so and I don't have the sound turned down, y'all. They're at the bench, so we're not.
Oh, but do you have bloops? Because we were behind time.
Yeah, Jay, another question. They asked if they could get a second
Pizza
because they're very hungry and they want this one with pepperoni and mushrooms.
really trying to milk
sausage.
every penny they can out of this.
So what they asked was for a second laptop because they want to be able to look at the digital evidence. And I mean, they're 6 hours into deliberation here. So Allie had asked like what was presented. The first question being, wait, Carol's saying I'm very loud. Sorry, Carol. I don't know if there's anything I could do. Everybody else is saying I'm normal. Do I sound loud to you guys? Let's see. I'll click it down to like a 42.
Nobody
How's
has
that?
any ideas from what I'm seeing here. What about that like 1%? Unless other people were just fucking around like me.
Deja keeps saying that he's wearing a hoodie. What does that mean? When?
Like a hoodie and then a hat.
But like, what evidence do we have of that? Where was he wearing a hoodie? When?
She's just saying that that's what she thinks, where people are thinking it's a
How do you
hair.
know what she's saying?
I think that's what she's saying.
Right. I mean, you don't know what she's saying. There's Allison, defense lawyer extraordinaire, right there. That's like any conversation I have with my kids.
Well, let's see. Let's see what her answer is. It's going to be interesting.
Well, I haven't paused it. We're just waiting.
No, I know. We're waiting. I'm going to see what she's going to write here.
Oh, well, somebody said to throw up a hoodie video.
Well, I think they mean the video where some people are calling it. Well, again, like you said, I can't be assuming what people are saying. Who was it?
Good. Well, I mean, out of respect for Carol, I turned it down a little more. So, all right, I think she's back.
Instruction number, what I say?
33.
Okay, it should be instruction number 33. And then please refer to instruction number 25.
Mark it.
I mean, Tejas is sitting there thinking he's got a shot.
Tell us. He likes
I'll have the court
the
officer
American version.
sign it.
No, he doesn't.
So everyone's been saying his name wrong the whole trial?
Yeah, because the first question that the prosecutor on cross-examination asked him, he's like, "You pronounce your name Tejas, right?" And he said, "Yes."
So how does his own lawyer?
I think that
And a
his
copy of
lawyer
this
did
will be
it
marked as court's
because they have
exhibit
an all-white jury.
26 as well.
And he didn't want his name to come
And
out.
Wow.
maybe stay close by.
I mean, the guy has to know how to pronounce his name, right?
I would assume so.
Yes.
I was going to say, otherwise it speaks to Tejas not even having enough gumption to tell someone he's pronouncing their name wrong,
I'll carry that back.
which doesn't seem like someone who stabbed somebody a bunch of times. You get the name wrong as someone who's going to stab you, they might just fucking stab you. Right?
So what are they doing? Did she answer the question? So I guess they agreed to give the second laptop. All right, so there's that. Okay. All right, so we're gonna go back to Richins. So
Thanks. At least this guy laughed. Tortuga.
Tortuga,
Tortuga.
the tortoise, the turtle. Okay.
Thanks, CH.
All right, let's throw this back up. All right, so okay.
He might have. This lawyer who would like go all out, like he's doing the most important cross-examination of the DNA expert and then just pretend that he just not even talk about it. He might have just changed his name to make him more white for a jury.
That's what I'm saying.
Or
what is it? What is the other
or this
explanation?
that guy doesn't have enough gumption to even tell someone they're pronouncing his name wrong.
His lawyer? The old gumption argument. I don't know. Pretty good. Pretty good one.
I mean,
They would call that the gumption defense.
There's no evidence that that occurred.
Well, the standard of proof is the same for every element of the crime, right?
But
do you
there's
ever
no
fuck
evidence.
a stranger in the ass, Bob?
Her business was
You get
based
stabbed.
here. I think there's a basis for reasonable belief belief that she was initiating these contacts, forming these schemes from Sunday County.
Well, I just want to make the record.
Okay.
I don't believe they've established jurisdiction or.
Yeah, so people are saying that his like the bastardized American version of his name is predates the crime, and that like when he was running for office, he like, but
He whitened his own name?
yeah, same thing.
Oh,
Same thing when
God.
you're running for
That's
office.
disgraceful.
I mean, like, I don't know what the
I'm calling.
Hispanic.
He doesn't even deserve Tellez. I'm gonna call him Tellez again.
Tell us. That's a way.
Or venue on any of those.
I walk
counts.
around saying my
I mean,
name's
that's a
Allison
political move,
Mota.
though, too. You know what I mean? It's like I always said, if I ran for office in Chicago, I would probably use my mother's maiden name, which is Morgan, because we have a huge Irish population here. If I were going to run for office in New York, I'd go with Mata because there's a huge Italian population there. So, you know, I mean, politics, man. Can't trust them. Can't trust them.
Well,
Furthermore, on the,
no sense of identity, huh?
I don't see why the two insurance fraud counts don't merge here.
Correct me if I'm wrong, I'm seeing several merger issues in this
Yes.
information, but merger is a fact issue that's handled after conviction. Am I right about that? Not
Yes,
just preliminary.
that is right. What the hell are they talking about?
Not after conviction, before, you said after conviction, you meant
Is
after.
it before so then you get to the jury or after?
Merger?
Yeah.
I always do as a pretrial motion, but
Okay.
I may be wrong, maybe too, you're wrong.
I don't
What-
think it gets considered though to preliminary.
What the hell's happening here?
Well, I think if you determine at a preliminary hearing that two counts are actually one act, that you cannot push forward one of them, absolutely, I think you can do that.
Oh, that's not a
Was
merger
that teaching
issue.
For that, I thought it was the opposite of a preliminary.
My goodness, she doesn't know what she's talking about.
Well, I think you would just argue that they
Like a
can't they can't make two separate counts, so there's not sufficient reason to believe that a second crime is committed because it's all one. So that's your finding, that it's a reason, you can't reasonably believe
Is
the
that a
second crime is committed because it's just one crime. Because the scheme swallows the allegation of the filling out of the application. I mean, it swallows it. So,
I'll take a look at this.
and then I think on the rest, we would just submit on the other counts, Your Honor.
All right, so let's just be clear, to the extent that merger needs to be considered as part of the probable cause determination, that's gonna mean that 1 and 3 merge, right?
Yes.
2 and 4 merge.
No, not 1 and 3. Attempted murder is on a separate day. It wouldn't.
1 and 3, 2 and 4.
I'm sorry, let me look at what 1 and 3 is. I'm getting my numbers mixed up.
So the distribution counts merge into the ag murder and ag.
No,
and
she's-
intent, right?
She's
No, those would be two separate crimes.
Tell me why. You can't
Because
commit them without doing the distribution, right?
Right. I think they don't merge though. They're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay,
So
so
they wouldn't
then why
merge.
isn't, on the one hand, forging a signature and on the other hand, making a false statement when trying to
those don't merge. Whatever she's trying to
collect
say
on a
right now.
claim? Why aren't those two separate crimes? What is
They
the
are.
merger
Because
you're
they're
arguing for?
the two insurance fraud charges, because that is the same offense. Insurance fraud is not two separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the two insurance fraud charges. I think they merged.
Alright.
And
And just to be clear, you think they merge because it is the same fruit
Statute?
of the criminal conduct, that is, there was only one policy.
right. That's correct.
Okay, I understand.
That's correct.
Thank you.
Same
Thank you.
underlying
Can I just have
conduct.
1 minute before I sit?
Of course.
Could you imagine going in and having a discussion with the judge about
Just 1
What?
What? She's like, well, I don't know. I thought you do it pretrial.
What?
They were
Well, I
talking
guess
about.
maybe the last thing I would say too is
I can't hear, so I don't want
there's
to talk over.
so many reasons that Mr. Richens could have not felt well that day and taken a nap. And to get over the hump of saying you're gonna stand trial for attempted aggravated murder.
Oh,
which is
hell
the-
no.
The next to most serious charge you can ever be charged with because he went to take a nap.
It's a
Pushing it, Your
specific
Honor. We're just
intent crime.
asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, the prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say, this one will not go forward. And we submit on that.
Okay, thanks, Steve. Thank you. Mr. Blow.
Your Honor, real quick on just the merger issue, it's two different policies. Count 7 relates to the $250,000 two-stage policy. Count 8, I think, relates to the $100,000.
That is not the way it is charged. I think that is, you're gonna need to amend the information if you want to do that. And frankly, I don't think there's any allegation of fraud, or there's any, tell me why there's any reasonable belief regarding fraud related to $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richins.
That's not what she said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's two separate diaries. This is why I'm asking.
Your Honor, I think in,
Man, he's really got a handle on this shit.
sure, in the one diary, though, they discuss both policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday. They are separate diaries regarding separate policies.
Let me ask you this, sir. Is this an issue you're considering, and so I can show it to you, but I don't know that it's.
I understood you to be saying count 7 is based upon statements made during the process of collecting.
I found it.
It's in June. Count 8 is the scheme to get the policy with intent to kill Eric Richins to collect.
Sounds a little bit like conspiracy. That doesn't merge. But attempt would. Is it a different subsection or not?
Are you referring to the statement, Mr. Burmester, of no known drugs, occasional cannabis use?
No, that,
That came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
Man, this judge literally knows the evidence like the back of his hand.
Yeah, he's a good judge.
He's young.
I see what you're referring to. So this is 1803.
Young and good. Thorough.
Hold on a second.
Not
Let's get
winging
Thorough.
shit.
I wonder if they always have hearings like that. Oh,
My apologies, I had it backwards. Okay, so count 7, thank you for this clarification, is with respect to the $250,000 policy. Got it. Thank you for that clarification.
Your Honor, regarding the 404B discussion,
other bad acts.
the purpose of admitting the evidence is
To establish
further to many of the exceptions.
planning.
Propensity.
No.
intent, Preparation, lack of accidents,
What?
nearly all of them.
Do I live in a different
404B
world?
relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is relevant.
Propensity?
The most of the defense argument against find over the attempted homicide count. As the court kind of noted, a lot of that goes to the jury. A lot of that was arguing countervailing evidence. As the court is well aware, the standard today is notwithstanding countervailing evidence.
Right,
whether
that's true.
Countervailing evidence of how
Doesn't like to
clear
say countervailing.
Richens eats his eggs, or whether he was shot beforehand or afterhand. It's countervailing evidence. It does not apply to the court's analysis today. Part of that countervailing evidence, I find it ironic that the counsel argued we hadn't heard one piece of evidence from Eric Richins. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is
Is what?
evidence of
Plan.
other acts
Motive.
admissible to prove an MO.
Right. Motive. So
I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
You know, we've had some discussion with defense counsel also as it relates to the standards that issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all reasonable inferences, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps, certainly. But I don't even think it's necessary for the court to get to a probable cause determination. And, you know, Schmidt, in discussing probable cause, references that probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information.
Or a search warrant.
Or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah, 100 of them would issue that warrant.
Check to speculation.
It's
Right.
argument.
The hell?
oh my God, I thought I was missing court.
I understand the state's point.
It's
Okay.
tomorrow.
It is 11:29. We're going to come back at 11:50. Oh, is Nestor, my
Very
apologies.
Quickly, I checked the ME report. It did reference the fact he was positive for COVID, but
Okay.
it did not talk about allergies in the ME report. That's where I thought it might be. But I'll keep looking and see if I can find it. But I do know that he did test positive for COVID.
Understood. Thank you. 11:50. Court's in recess. Thank you.
All right. So I think it's just coming back for a ruling. Right?
I mean,
I don't
if
think
he-
that
if he's not even going to just rule on paper, I mean, they almost usually just say it right then and there.
Jay
That
thinks
might be like
that,
the
they should
courts
use
do
the
out there.
young bespectacled attorney that slightly resembles Steve-O. There's another actor that guy reminds me of, and I'm trying to. He was in. I'm gonna find him. He was in the show Oz.
Which guy in Oz?
Hold on. I'll
White
tell
guy
you.
or a black guy?
No, Hispanic guy.
Hispanic.
Kirk Acevedo. That's who that guy reminds me of. I'm gonna show you. So Jay was talking about he was talking about which trial is that with Acevedo? Is that with
What do you mean, Jenny? What did they do retrospectively?
well, she's saying because they charged the attempt, the aggravated attempt murder way later. Way later, they added that charge.
I mean, they can do that until the statute of limitation runs,
Yeah,
which is
like,
probably for attempted murder very, very long.
but I
If
think
not,
it is,
if not the full extent of murder.
it
which would
it
be-
is an interesting and pertinent 404B argument, though, that they're only doing that. It's like with the burglary charge in Garcia, it was the same shit. Added that later. It added to their narrative. It was a narrative piece for them. They didn't care about that.
I don't
charge.
understand why they're talking about 404B at a prelim. If they charged that very offense, why I don't know why they were having that discussion then.
I think she was just trying to pull shit out of her ass. Is why she had that discussion.
Yeah, but the judge said something about 404 and then the state did again.
I don't know.
Like
Yeah,
if they were trying to sever the charges or something, that'd be relevant because it'd be like, well, it's getting in under 404B anyway, so you don't need to sever type of thing.
okay, so all right. I want to share one other.
That might have been what they were talking about. 'Cause I don't know if the judge makes that determination at prelim. I've only ever filed motions attacking the indictment
All
after
right, so somebody
indictment,
tagged
not
me.
case.
Somebody tagged me on this. I want to pull this up on Twitter. Brandy put this together, I think. Super interesting. All right, so this is the hoodie that everybody's been talking about, babe.
So it is a hoodie.
Well, he owns a hoodie.
Oh, I thought somebody cleaned up the freaking picture somehow.
What?
I don't know.
We think we live in magic
Magic.
world. Yeah, no one did that. But she took this picture. Now, was this? So the next question becomes:
Yeah, it looks like what's going on.
could be,
Yeah,
could be.
doesn't look like hair now.
The question then becomes: I don't know that this photograph was introduced into evidence. Was it
Which one?
the one with him in the hoodie, babe?
Oh, that's the side by side we're talking about.
Holy shit, dude! No, the side by side was with him walking. This is from my Twitter.
Right,
People
but
were saying he's wearing a hoodie. What I'm asking people is, was this photograph for any reason ever introduced at trial? If the
Oh.
jury doesn't know this picture exists in the world, it doesn't matter.
yeah, I'm sure they don't. How would they get that picture in?
I mean, they had other pictures of the dude. You know, they had him like walking like in a hallway. They had
Is he trying to
interviews.
hide his bald head?
I mean, at least wearing a fucking hoodie. Like I don't know what he's wearing a hoodie. This could have been from like October of 1997. I have no idea when it's from. Somebody just found a picture of him with a hoodie on, and they're like, "Oh, that's what it is." Or somebody photoshopped a hoodie onto his bald ass head. I have no idea. Do we even know if he actually owns a hoodie? Oh yeah, Auntie Bev knows. Auntie Bev knows. Jay, what?
In the top picture, you can see it's not a real hoodie because it.
Well, no, honey, that's a cut and paste that somebody just stuck on a different picture. I'm talking about the smaller one down here. This one. To me, it kind of looks like it's photoshopped on.
Right, because it looks like it's the same as the one above it, just a different.
Oh my God, it is the same as a
Right, and that's definitely photoshopped on in the little one.
Holy shit, dude. They took this picture, the bottom right,
Right.
and photoshopped it onto the image that's in evidence. So those two pictures that you're looking at, the small little head to compare the side by side, is this picture from down here. So just focus on that picture. I think that the bigger picture, you could tell it looks photoshopped to me.
Well,
Like, does he actually own this hoodie, or is somebody just like figuring shit out?
it's the reason I was asking is because in the little one, and I understand what you're saying, why are the shoulders red? And the way that things hanging. Or is that not really a body, even in that? Is that
Wait,
like
where?
oh, I see what it is. That's the middle part of the car. Okay, the spot between the two windows. Okay, never mind.
Wow.
I was thinking it was like a part of his shirt. Ugh.
Yeah, so this is definitely photoshopped. Yeah, I mean, like you could
Either
do
way, that's what he'd look like with a freaking hoodie on. Looks kind of.
well, I mean, maybe that also could be hair though.
I don't know. It looks pretty hoodie like.
It kind of looks like good hair guy from like his lawyer, the good hair one, like what his hair would look like at a
What you're
side.
talking about at the top looks like a hat.
It does
It
not
looks
look
like a hoodie over a hat, over a
I do
baseball
know
hat.
what kind of a hat. I don't see a hat there. Definitely not a baseball hat, bro. Like for
Well,
you
it
being
comes
married to a
out.
guy who like wears baseball hats all the time, it's not what a baseball hat looks like.
But it's pretty
It's
firm
definitely not a baseball hat.
to be the little part that hangs over of the hoodie.
I mean, that's the only thing it could be. I mean, that could definitely maybe be it. Maybe. It does look like there's like specks there. It does. Like I agree with Teresa. It looks like I could see the nose, and it kind of looks like the person has glasses on right there. I don't know.
What?
Okay, yeah, that's what matters. I'm glad to know that
The
this.
screen's all the way down. My brightness was all the way down. I can see a completely different thing now.
We can barely hear you when you don't talk into your mic. Those shures, you have to really talk into that mic.
So I had my my brightness down so low I couldn't see anything. Now I can actually see it.
Yeah, but the noses do look different, Taylor. But like with that,
How come it looks like a
the image is distorted. Like that is a very like I can't pretend to know what the actual nose looks like from the side from that image. It's like you can see everything looks distorted.
all right, well,
You
right
see
now
how
you
like I
see a
mean,
big
just look at
giant
like
box, right?
look at the window frame. Like I mean, we all know that there's not a million bumps on like this top portion of the window frame. You know, like right, like where
Oh,
like
there it is.
the red portion. It's so distorted you can't tell anything.
Oh,
Which is why the jury wanted to be able to blow it up. It's why the jury wanted to be able to blow it up. So, I mean, look, here's the bottom line. I mean, the defense doesn't have to prove a goddamn thing. The state does. And the question becomes, did this defense attorney, who Jay and I thought did a very, he didn't really even touch on the whole Compass Realty thing. I think he said the word Compass Realty or those words like once, but he certainly wasn't doing what Karen Reed's attorneys did, like full blown diving into the conspiracy, trying to prove that there was somebody from Compass Mortgage that hired a hitman to go. Like he didn't do that. What he did is he poked holes, tried to poke holes.
He's I've never seen anything like it.
Never seen anything like what?
I keep talking about it, how he's like acting like he's going all hard. And then
Who?
just like he sits down like he dropped the mic after he just ignored like the DNA guy. Like when he cross-examined the DNA expert, the woman. Like was making
Oh,
all these
you mean the defense attorney?
yeah.
Okay. All right. So here's what I'm gonna do. Kirk Acevedo. All right. So
Oh,
like
this
Jay,
guy's
what
coming
trial is
back
that?
now.
This is who the guy he keeps calling Steve-O really looks like. This dude right here. That's the guy. That's the dude.
From The Wire?
He's not as no Oz.
Oh,
He's not as
Oz.
like granted, it's not as funny as Steve-O.
Was
it's
he like a
I
girl in
can't.
the Oz or
What
like
trial is the Steve-O guy? Is he Richins or like it's all blurring together for me? Jay, like is he at the Kouri Richins trial?
if I was bald and I was gonna kill somebody, I'd definitely wear a wig.
Yeah,
That's
definitely.
that's what Kavlaw said, for sure. So
Yeah.
was he one of like the girlfriends in Oz, or was he a tough guy
Jay
in Oz?
said
I
the
can't remember who
Richins.
he was.
He was one of the prisoners, babe.
I know, but like like one of the girlfriends or one of the like tough guys?
I mean, they were all kind of tough in their own way. That was some violent shit in Oz.
Well, I know, but they did have like the more, you know.
No, Leslie, the actor did not commit a crime. Jay likes to call the lawyer. Let's see if I can find him here. Let's see. Get a shot of Steve-O. They show him very rarely. It's very rare. Like they don't even show him today, really. Oh, there he is. There he is. All right, let's see. Okay. We're gonna crack this case. We're gonna crack it. We're gonna crack
Yeah.
this case right now.
It's been cracked.
There's
Unless someone in the chat can tell me what the hell the jurors are
there's
talking
Kirk
about.
Acevedo / Steve-O.
That guy?
Yeah, there you go. Yeah, Miguel Alvarez, and yeah, he was a tough guy. He's a little dude though. Jay's dying on the Steve-O
Oh wait,
hill.
now maybe I'm picturing when you said I'm gonna pull it up because
All right, let's see. Stop turning that. All right, so let's go to a picture of Steve.
oh, we're supposed to visit Aaron's bar when we go to New York.
Sounds like why are we talking about that on a live?
I'm just reminding you.
Well, we'll see.
Well,
Oh,
stuck
wait,
in
I
the
found
car
a
with-
picture of Steve-O with glasses. Let me get some better images of Steve-O. Okay, this is a good. All right, this is a good one. This appropriately represents what Jay is saying. So I could be with Jay on this one. I could be with Jay. All right, let's see. All right, so that picture right there.
Yeah, then now I'm with you. That's the same guy?
Definitely. Jay says, "How dare you question my doppelganger abilities?"
Wait, is that the same guy?
No, Shmoo.
Oh, I
It's
was
not
like,
the same
I thought he
guy.
was like putting on
And
a
this guy's
skit.
definitely got a different nose than Steve-O. I wish we could get a straight version though, like a front view.
Is this guy's shtick? He's always like that?
Yeah, Jay's typically spot on with his doppelgangers. No question about that. No question about that. So, all right, so we'll go with Steve-O. Jay wins, I lose. All right.
Definitely.
Yeah, because I mean, we're gonna have to have a nickname installed for when that trial goes, which I think that trial's not going until probably next year. So that one's a way off. That one is a ways off.
So how long do you have to? You guys just gonna sit here talking about this until?
No, I'm about to end this live, and then what we'll do, I will keep an eye out on a verdict. Obviously, if a verdict comes,
I want to give the chat one more chance. Somebody tell me something that this jury is thinking about. Anyone?
Are you waiting for them to type it? I'm telling you what the jury's thinking about.
What?
They're thinking about the closing, namely the. Oh, I thought. All right, here's what I'm gonna do. This is what's about to happen right now. So I'm gonna go. All right, so this is off grid here. This is what I'm gonna do. Okay.
Yeah.
Okay.
Everyone's saying hair or food.
All right, let me see where we're at here.
I guess the lawyers thing worked and they're all ignoring the DNA.
See, that shit sounds loud as hell.
Me?
No, not you. Oh yeah, see the boosters on like eardrum piercing levels. Okay. Okay, so I'm going to pull up some of the closings from yesterday since you didn't have the ability to be able to see it.
Oh, no, I figured I'd watch that when you shut this down.
Of the car and then using the work
So
computer to
she gave the opening, closing, and then his lawyer.
She did both.
No, she didn't.
Oh, I
What
thought you said she did it, the
on that,
opening and the
man?
closing. I was
She
asking.
did the opening, closing, and then
Oh, he ended.
Jeff
Schneider Jr.
Merriman
did the
DNA
auto closing.
wasn't anywhere but at the scene of the crime. And this is significant because we heard a very able explanation of the state's evidence from their point of view. There was no blood or DNA evidence concerning Mr. Gehrman in Mr. Tallis's home, in or on his vehicles, in or on his clothing. None of that would implicate Mr. Tallis. There had been discussion on the state's closing wherein there was blood everywhere in this, in the bronze circle address. Obviously, it was a stabbing. You can see through the exhibits that you will have with you in the jury room. There was blood everywhere, on the bushes, on the bird dish. Nowhere in Mr. Tallis's vehicle do we find blood.
It's
You recall
irritating me
testimony,
that he's saying the
blood
wrong
presumptive
name stuff.
negative on both doors on the driver's side, the seat belt, the brake pedal, the gas pedal, the mat, nothing. There was no blood on his person, clothing, anything else. You got
Yeah, no, look, Mega, we were talking about this. This is why I want jurors doing this. Like, you're talking about people's lives. It's like we all sit here and chat and, joke and laugh. But like when Allie and I are in a court of law dealing with somebody's life, we want jurors going back and actually deliberating. We want them questioning the evidence. I mean, that's what you want happening. It's like we're as a society, we're so, we want everything now. We want everything in short little bits, including jury deliberations. We want a verdict immediately. It's like,
I saw the man testify. His answers to why there's 500 pictures on his phone was, I didn't do it. I don't know. Like, I just what?
yeah, I know. I mean, look, but like you're asking, I'm going to show you what I have this on 1.5.
got
It's worth
no,
looking at.
you didn't hear from any witnesses concerning any personal knowledge to contradict.
No, I
Mr.
absolutely
Tallis's
appreciate
version
that, Meg.
of the events.
Usually I'm the last
Number
one to
seven.
convince somebody's guilty.
There was not a positive identification of the subject vehicle or Mr. Tallis at the scene. There's no evidence whatsoever of any gloves being recovered. And you've seen, it's fairly clear from the video evidence that you've been presented that the assailant was wearing gloves. There was no recovery of a murder weapon.
He
That
makes
vest
a
with the
list
reflective strips, you didn't see that?
of
And the
nothing.
pants, I mean, we had
Sounds
pants that were
kind of
recovered.
like
You
making
saw
a
the blue
list of
pants.
something.
Obviously, that didn't bear any evidence to
I don't know.
implicate
This guy, he's got
Mr. Tallis.
something.
And I would say
What?
I said, this guy's got something. It's like he's making a list of a bunch of nothings. It was like that list that they made. Actually, I
Wait,
hate
this
like
dude, I don't think these are a bunch of nothings.
I know,
think
but
that
the
these
way
are
he's
things that
stacking
you would
them,
otherwise want to see when convicting somebody of murder.
but it's
right?
kind of like he's saying the same thing in different ways.
Well,
It's like-
I mean, all right, so let me devil's advocate with you. Okay, so knife murder, we know that they're very
yeah,
bloody
very,
events.
very bloody.
Okay, so we know if that is Teaz or
He
whoever
should be-
that is in that car
He should have
is
sunblood on him.
is wearing the orange jacket that we saw the offender walk up to the crime scene after he comes back to make sure that he didn't forget anything. So he's in the car with theoretically a bloody jacket on. They find not an iota of blood anywhere in that car. Okay, and we know that they were watching him.
Something the dark web knows that the rest of us
We
don't.
know that they were pinging him. Like he was on their radar. Like if he would have gone to a car wash and scoured the hell out of the inside of that vehicle, we would have known about it. These are the things that we would have been arguing too. Like, where's the blood inside of the vehicle? Like, yeah, you saw him washing the outside of the car. Who gives a shit?
Hey, I'm not faulting the guy. I'm just saying, me personally, I'm noticing like, even though his list is not that compelling, he's making it seem like he's saying something super compelling. Yes, it is obviously compelling that there's no blood
I think you
from a
only
bloody
feel that
crime
way
scene.
because he didn't address the DNA under the fingernails. That's the only reason I feel like you feel
There was
like
more than that he did. There was more than that he did. I was like, yeah, clearly I haven't gotten over it, but there was something else like that he did, and I was just like, wow, this is fascinating. But you know, it's like whatever.
Submit to you that the facts
I'm
and
not hating
common
on him.
sense would
That's for
dictate
sure.
that had he been the murderer, there'd be evidence of it on these articles, on that getup that person was wearing on September 2nd.
Under his
get up.
This is a point that I would urge you to consider because I
Look at
would
his
submit to you
face.
that's
He's like,
crucial in determining whether the state, and again, it's the
We're
state alone that
ignoring
bears
my
the burden,
nails.
has proven their case against Mr. Tellis. There's no surveillance or eyewitness testimony showing that Tellis left his house that day, headed to Mr. Gehrman's home. We did hear evidence, and it was uncontroverted, and that came through Detective Gaddis, that on the day of the stop, September 2nd, it's Metro policy to have body cam. The officers that stopped him in relation to the warrant that was obtained with Mr. Jappy's, Detective Jappy's participation, it was issued at 2 a.m. on the 7th. The officers that stopped Mr. Tellis, the officers that detained Mr. Tellis, didn't have the body cam on, and that was requested multiple times. Ultimately, there was an order from Her Honor on July 18th of 2023, and after that order. And you recall going through the reports, the CAD reports, there was intervention, but again, that key piece of evidence was overridden. It was destroyed.
Why is he in
Again,
his
is that an
hand?
indication of some wide-ranging conspiracy? And I'm not going to stand before you today and necessarily argue that there was. But what that shows is that Metro makes mistakes. Metro officers, Metro detectives are human. I mean, you think of the old proverbial idea of police officers, they're brass buttons, blue uniforms. They're human beings underneath their titles, underneath their uniforms, and they're just like all of us. They make
Kavlaw,
mistakes.
I
That
don't think
shows you
Murdoch
that
did his
mistakes
family.
are made on behalf of
Love
Metro.
you
I think he's
and
a good
yell
The
and
Las
lawyer.
hate.
Vegas Metropolitan Police Department
I think
is
he's
not
a good
infallible.
lawyer.
Let's talk about Robert Tellis's blood or the lack thereof at the scene of the murder. You had seen some pretty good videos capturing that person leaving Jeff Gehrman's house after the stabbing.
Ooh.
I would submit to you that it's the state's argument that Mr. Tellis cut himself through that incident. You heard his testimony. You are the sole judges of the facts concerning that. What we do have, in addition to the state's video, is we have this assailant walking away from the 7217 Brun Circle.
What about the
address.
200 pictures?
That finger was cut. That finger had been damaged by a knife or otherwise severely injured. Wouldn't there be blood? Wouldn't common sense dictate that there'd be blood in the bushes surrounding Jeff Gehrman's body, in the rocks which were recovered, in the sidewalk outside the house? Nothing. And again, it's the state's burden to present you every bit of evidence in their prosecution, and you should take into consideration the evidence that they've presented to you. But by the same token, you should take into consideration determining whether or not they have proved their case beyond a reasonable doubt, and they have the sole burden for the production of evidence. Ask yourselves what evidence is missing. Let's talk about Robert Tellis's body
Oh, no.
in relation to a struggle that the state would have you believe occurred between these two gentlemen. Recall the evidence that we had brought in
Is it far?
during their presentation.
Leslie, there are actually good people out there. You'd be surprised how many times people have turned shit in. Yeah.
What's the tire thing
Why?
to fill
What?
the tires?
What do you mean, a pump?
You're doing a bike?
Mm-hmm.
I'll come down and help you.
Of evidence, and I believe enough of these pictures came through Detective Gaddis. And there's a lot. It's defense exhibits B through
Gonna
V
leave us
This is
stuck
just
up.
kind of a
Leave
capture.
pause.
of these photos, and there's a lot of them to evidence that there were no injuries to his body. Neck, front, and there's more. And we could stand here and click through each and every one, but we're not going to. You can look at them. You can ask yourselves, well, if there was this struggle, where are the markings? Where's the
Can
bruising?
someone tell me why he
Where are the
stopped
scratches?
leaning on his
Defense
hands?
exhibits B through
Why is
V
he he's making a
will
real
demonstrate
murderer
that there were no
face
such
now?
injuries. Let's talk about the cell phone usage on 9/2/2022.
Yeah, let's talk about that.
You know, the state would have you believe that Mr. Tellis's lack of responses to junk messages mean that he was occupied with murder. And through analyst Aguero, you heard, and you had the opportunity to see through the course of this gentleman's testimony, it was uncontroverted. We went through the messages during the key hours, the key times of September 2nd. The vast majority of those messages were automated. They were spam. How many of us respond to spam? It wasn't like he had every person reaching out to him, family, friends, repeatedly. Where are you? What are you doing? It's not. The vast majority of those messages were of no significance. They were junk. Additionally, the state did not establish a pattern of phone use behavior, which would indicate that Mr. Tellis' communication activity on that day was anything different
I
than his
noted that
normal
too.
behavior. They had the devices. They had the access.
That's,
You heard no
that's
testimony
the
that his
defense.
accessing his
That's
phone,
how
his
the
using his
defense
phone
gets
on September 2nd was
a little
anything different than the day before, the day following, the weeks before, or the weeks following Mr. Gehrman's murder. And let's talk about the deleted messages. You recall, that was quite a big point that was underscored and argued through the course of testimony, and it was actually through Mr. Aguero, our expert, the issue concerning this deleted message. And you recall then we had the subsequent witnesses in the state's rebuttal that came forward with and it was through Mr. Tellis's testimony. You remember the watch, the Apple Watch? Then there was questions asked, what about the other device that presumably these messages were being received on? We didn't get the benefit. And again, it's their burden to compare the Apple Watch with a Pixel phone. We didn't have that. But what we did hear from that detective is that he couldn't say one way or the other. Do you remember that question, where are you? Obviously, if someone's home, they can speak with one another. But we didn't hear and we couldn't hear any evidence. And for you to just make a judgment based upon their own expert, their own witness who has special training and knowledge, say, I couldn't say one way or the other whether that message was deleted on the Pixel device, the device that they have alleged was
Bob
Mr.
could
Tellis'
text
phone.
me from upstairs and I won't
That's
see it for 3
significant.
hours.
Let's talk about what the state does have. They've got a cut up straw hat and shoes. There's really no reasonable explanation, rational explanation one way or the other. Obviously, if this person's the murderer, why not get rid of the shoes? You'd have to presume that he had knowledge of the shoes and their whereabouts. Let's talk about that hat. Why wasn't that hat discarded? Again, we'd have to presume knowledge on the part of Mr. Tellis where that hat was. And again, neither the shoes nor the hat tied him to Jeff
Getting to
German's
do his little thing.
residence. We had a shoulder bag with balls in it. Do you recall that exhibit? We had a basketball and a football that looked like some sawdust, and you'll have all of these exhibits. What's going on with that? I guess you're to use your common sense, which is one of the latter instructions, and assume that this bag is somehow implicated in the murder of Jeff German. And then it winds up in a storage area in the family home with a basketball and a football, and what I would submit to you looks like sawdust in the middle of it.
He's like, tell them about
The image artifacts from the cache of Robert Tellis' phone, as well as the vehicle and the address inquiries on Mr. Tellis' work computer.
Yeah.
It was fairly clear through the course of the testimony that that work computer had access to the Google account that would presumably be accessed by his Pixel phone. If one has password to that, one can have access to the devices. Matt Havaness said that he could not say the date of the cached images on the files of Mr. Tellis' Google Pixel phone. We were shown a calendar. We were to draw inferences. We don't know specifically who accessed, who searched for those images, and we don't know when they were created. And I would submit to you that that's significant, and the state should explain that to you. On Defense Exhibit 03, Robert Tellis' user accounts on Dell Omnivex located the Public Administrator's Office. Again, this is the report. You have it. This is Mr. Aguero's summation of his analysis. Again, it shows that this Google account where these damaging photos and images are shown, it's the same. It's the same account. It can be uploaded, accessed by both the cell phone and the work computer. Obviously, we know what was going on from the testimony of multiple witnesses, what was going on at the Public Administrator's Office and the turmoil. I would submit that's something that you should consider and determine what the facts are and what the state has proven beyond a reasonable doubt. There is a positive DNA hit for Mr. Tellis.
Oh, here we go.
Jeff German's fingernails. And you recall at the beginning of the state's presentation last week, you heard from the crime scene analysts, and I would submit to you that it was fairly clear that there was a little less than an airtight investigation because, after all, police officers, detectives, crime scene analysts make mistakes. Reference to the lab techs, Ms. Brown and Ms. Koljenovich, they were trainees at the time that they did this DNA collection and the processing for presumptive negative or presumptive positive blood evidence. This is significant. It was Claire Manning. She had testified she was young, blonde. She had testified that she couldn't recall who bagged the hands. That was at the scene of the murder. You never heard testimony as to who initially bagged the hands of Jeff German's body. One would think, and common sense would dictate, that they'd be able to tell you that. They couldn't, not from a single witness. She testified that she took custody both of the fingernails and the evidence concerning Mr. Tellis, but again, she couldn't tell you who bagged the hands.
Wow.
Again, this Google search on the recipe, you heard
So
that
good
this
at
the
making
last
points
day
that
of trial,
mean
that was
nothing.
somehow significant. Do you recall in the recross of the detective, there was at least 2 computers at the Tellis home that were not reviewed. They weren't checked for those recipes. So again, I submit to you, we have a wash. Detective Mogg, Christopher Mogg, he's now retired. He's an analyst, he lives in Texas. Do you recall at the beginning of this trial, he gave what appeared to be fairly detailed testimony
later
concerning the whereabouts of the subject, Denali? Do you recall on cross, it was addressed that at 9:10, that vehicle was entering in from the Piggott Elementary. Again, you saw the map. It's in evidence. You can see that this right here is not the entrance to Mr. Tellis' neighborhood. It's streets away. It's not close. He gave you testimony that apparently he drove through the neighborhood where Mr. Tellis lived, off the Spanish Steps address. He said to look for things of evidentiary value. We heard nothing. We heard nothing concerning other vehicles in the neighborhood. Do you recall the testimony that there was at least 67 red Denali's? We heard testimony that that number at one point perhaps was greater. Perhaps it was at 67, which nobody contradicted, but we never heard what it was ultimately narrowed down to. We had Detective Mogg, and I'll refer to him as detective because in essence he still is. He testified and just said he was sure that it was that man's Denali, period. Do you recall the
It
testimony
had
that was shown
tires.
concerning? I would submit to you because you
It
are the
had
sole
windows.
judges of the facts that there was
It
something
had a
peculiar
steering
about
wheel.
this Denali, something in the right-hand window area, that
Windows
plastic
down.
stripping. You have the photos. Please look at them. We were given testimony based upon his analysis. We have at the same part near Piggott Elementary. We have this vehicle leaving at 9:12:32. But what's significant about the 9:10, where we see it entering the neighborhood or the area, again, it's not Mr. Tellis' specific neighborhood. We're not told where it was before that, who was driving it. What's important, and I want to back up, is at 9:10, we have this vehicle entering the area. And you have to ask yourself, what's occurring between 9:10 and 9:12? If we were to take the state, based upon the evidence that they have presented, what went on during that 2 minutes and a few seconds? We don't know. Did it even make it to the Tellis' house or some other neighbor, other house in the area? But as of the 9:10, it's important because it's the state's theory, and we heard it argued that Mr. Tellis left his phone. Well, we have, and this is Defense Exhibit A3, we have that phone receiving messages. Look at the times all throughout the morning. We have that phone receiving messages 7:44, 7:45, 8:47. You can see, and this will be given to you. It's close to the cell tower next to Mr. Tellis' home. So then you have to ask, well, where was this vehicle? And I asked him specifically, did you follow this vehicle? Did you see this vehicle prior to the 9:10 time taken from Piggott? He didn't. But we can see, based upon the evidence that was provided to you by the defense expert, that phone is in the area all that time. It's in the span.
All right. So you get the vibe.
Yeah.
Okay. So we're going to get to, all right. He's got another little list
I mean,
here.
it's
Can read
your
through that
regular,
real quick.
these are not the droids you're looking for.
Yeah. These are not the droids you're looking for.
Wait, he did say
Yeah.
compass. I saw
There.
compass.
Then there's that one, that slide. Super compelling. All right. So people had asked, want to see Hamner, also known as Schneider Cuters. He's got a.
Meg's asking, have you noticed a difference in how people react and act?
It makes no sense, and it's not supported by the evidence. And
You have it sped up?
Yeah, I had it sped up for him for defense lawyer. It's at 1.5.
again, if Compass is literally willing to kill, why not just kill him? Just kill him. Why does Jeff have to suffer? It makes no sense, and it gets even worse. Well, before we get to that, here's the thing: when we go back, when you think about the Compass question, right? Isn't Compass in cahoots with Rita Reid and Alicia Goodwin, right? They're funding Alicia Goodwin, right? Or not Rita Reid. They're funding her campaign against him. And who do they get to help write the story? Jeff Gehrman. Like, why would they kill the guy who wrote the stories that got this guy out of office? Why would Compass do that? That doesn't make sense. And then, yeah, if it's really a frame job,
You're framing
the
him.
murder
Look
weapon
at
should
him.
have been in the house.
Well,
You
the
Pause it,
counter
pause
argument is simple. The answer to that question is because it would look like he was the guy who killed him because
Right,
they were
well-
writing the shitty stories about him.
That's what Tay has made that face. He's like, my story is rock solid. They want to, who else to kill if you want me to go to jail for killing someone? It's just, why is that the choice of, method to deal with him?
Open the garage, bring the bikes back in.
Brother.
Dude, I know. Trust me. Yeah, I was desperately trying to talk, like, because it's, I don't know
Who
how
called
hot
who young and blonde?
it feels like what I imagine it feels like to be on the sun outside. Like it is, the humidity level it's like New Orleans humidity level. And it is, well, have you been
Yeah, I
out?
went out.
So you
Yeah.
know. So she's talking about riding a bike.
No.
Like her and
Does
her-
she have her inhaler with her?
I didn't. I said, okay, well, you're not
She
going
just had
anywhere
me pick
without a
her up in the
I
subdivision.
know. It's like her and her friend. They've got bikes out. She needs me to put air in the tires. I'm like,
They can
dude.
ride right around the cul-de-sac.
So my whole thing is, I'm like, well, you're not leaving without water, and like, when in 2 minutes, when you feel like you can't breathe, I want you to turn around and come back home because it's
That's
too
why I
hot to
said
be
just
out.
go around the cul-de-sac. Then they don't.
The point of the story is that I won. They rode off about a minute and a half ago.
Oh, and they're back.
Now they've returned saying that it's way too.
Daddy, you're right. It's too
Sometimes you
hot
just
out there.
you got to let them learn the hard way, right? All right, so
At least I didn't get
where?
called to pick them up this time.
All right, I want to try to find the side by. Oh wait, here we go. Side by side time.
Bag, right? I mean, he said that's my kid's sports bag. So like, probably need to bring that back. I'm not sure what he was doing with the hat. I'll admit, but clearly he's chopping it up to try to get rid of it, just like his shoes. And why kill Jeff? But this is
Look
the
at him.
question.
Look at his face.
So instructive to this
Oh
defense.
my God.
It's his writing that shines a light on his behavior.
He can't
He is
control
sought out
himself now.
by
He's doing so.
to do this. And he admitted on the stand, one of the rare times he admitted, yeah, his writing was the difference in the election. That's why I lost. I got that out of him. He was at least willing to concede that. But for
God
Jeff
damn
Gehrman,
it! I knew I
he's
should
still a
have
public
admitted that.
administrator. His writing is why the defendant is out of the job. And therefore, under this theory, he's got to be the one who's killed. That's his reward. He's collateral damage. Like, really? Rita and Alicia are like, sorry, Jeff, you've got to go. It's been really nice. Thanks for the help, but you're out now. We got to clean up loose. I mean, is that really what's being suggested here? And the answer is that is what he suggested. But it defies common sense. And it's not.
Look at him shaking his head. He's like, that's not, you got my
And here's the
plot
other thing.
wrong.
Jeff's putting together a fifth article. And now what we can tell from the records, it's just about Roberta and him. It's the salacious stuff. So who in this realm, if you think about everyone in the conspiracy, and you think about Mr. Tellis, who is the one that wouldn't
His
want another
wife.
article written about him
It is
engaging in an affair?
actually, instead of
Think
the
Derek
plot
Jaffe cares?
from The Fugitive,
Cliff Mogg?
it's the plot from
Adam
Gone
Fenn?
Wait,
Girl.
It's him.
whoa! You almost gave a massive spoiler for those who were you
Oh.
about to say presumed innocent?
No, but I guess you just did. I said Gone Girl,
Gone Girl. What?
but like in the reverse.
What? No one died in Gone Girl except
Isn't-
for the dude that she killed.
Right.
in
That's what I'm
order-
saying is like, you could, never mind.
That is
Who would
not
be
the plot of
motivated to
Gone Girl.
frame him, kill someone and frame him for murder? The wife he's cheating on. Who's got the car, who could put shoes in the house, who could go on his phone, who could, should have
Not Gone
he should have rethought his frame up. Everybody's seen Gone Girl.
Man, it's not the plot of Gone Girl.
It's like
He's the only one.
it's
that would
the underlying principle. Frame your fucking cheating husband for murder and let him go to jail.
Oh, I see what you're saying. I take it back.
Stake in making sure
It is the plot of Gone Girl.
that article never got written. No one in the conspiracy would want to prevent that coming out, especially not the Rita Reeds and the Alicia Goodwins. If they want that exposed, I mean, they went to have that exposed. They wouldn't want that being not put out. And I'm sure Compass Realty wouldn't either. I'm sure they would want it him discredited. Like another article would in theory be great. They wouldn't have killed him. And then we have his walk.
His walk. Let's
Like,
see his
he's
face.
got a little
He's
thing in his
dying.
getup where he kind of leans
Look at
to this
him.
one side. You can kind of see it. There's something that is about his little walk.
Oh yeah, that
and look,
that
you
when
don't
they
have to take
walk
my
it
word for it. You
normal-
can evaluate whether you think what
does
Zach
walk
and
funny.
Christy had to say about it. They've hung out with him. They've walked with him. They thought, and think about how they saw it. They were like, man, they kind of knew the background between Gehrman and Tellis, and they were like, wouldn't that be funny if that was him? He's got those same goofy gray shoes. Like that was the thing. Like they noticed the shoes, which I think is really interesting. You know,
What do you think?
but they don't act on it at first.
The
But it's
walk
only when they see the Yukon
does
that they kind
nothing
of slip
for
out. Like, well,
me.
we probably
The
should just follow him.
shoes do
They
everything.
came and said that wasn't him.
Because I
It's a
believe
weird
that
walk.
guy.
You'll have all
I
the
believe
full
that
facts. They
guy.
can submit to you that look, there's
No,
no.
It's like I'm
she
always
wasn't just-
bitching about the
The guy in the orange jacket literally is walking like he has shit in his pants.
yeah.
But like
I didn't think
Ellis has like a weird walk. He does have kind of a weird little
he
walk.
does, but it's not, to me, it's not quite as, I think maybe he was trying to make his walk worse. And that's why you've got the two walks. You know what I mean?
I mean, I have to assume that Tellis has seen The Usual Suspects. So, you know, I mean,
That's what he's doing. He's doing his Kozer Size.
Kozer Size.
Sizer Kose. What is his name?
Who is Kaiser Sose?
Sizer Kose.
Yeah.
Mr. Tellis, you can see it in the text messages. You can see it. You can go read through them. Ms. Davis admits
He's
she
like,
has a
I
bias.
can't change my
And, like,
walks.
she
I'm going to
cares
have
about
to
him.
make it
And-
work.
and I think he was probably good to her in the office, which is understandable.
So his
But
goddamn
look,
lift.
you can judge it on your own. You can judge the
He
testimony of those
should-
other
he-
people. It makes
we talked about
sense.
that he should have worn
When
lifts.
you look at this, think about all the
He's
other
so
evidence in
damn
the case.
short.
Think about all the other evidence. the motive, the physical things found in his house, his DNA underneath the nails, when looking at this and being like, is that him? And the state would submit to you when you put all that together and you watch this video, absolutely, it's him. Professional killer versus amateur killer. Mr. Tellis would like you to believe that this was an assassin with combat training.
If I would have done it,
You know,
it would have been
I
done
would
right.
submit to you, you don't need combat training to stab people. You don't have to go to knife school. You don't have to do that. If you're angry enough, you can stab people pretty good. You got enough hate in your heart, you can really go at people. And I would submit to you,
He's
the
not
state would
fooling
submit to you,
Dom's mom with
Mr.
that.
Tellis had
I'm gonna
enough
make my walk
of being
worse.
exposed, written about, publicized, embarrassed, and he wasn't going to have it done again. Because at this point, the state would submit, Gehrman had taken everything from him. Everything.
So is
Everything
he
that he
still
worked
calling
for.
him Tellez
He worked
too?
his way up through law school. He got himself elected, and this guy took it all from him. And so he wanted to take something from Jeff, and that was his life. Professional assassins don't use their personal vehicles. They don't use their personal phones or work computers to conduct reconnaissance. They don't wear attention-grabbing outfits. They don't flee the scene and then double back to pull right up to a murder scene to look for possibly dropped evidence. And they don't leave items of clothing or apparel they use in the murder inside their own house. Professionals don't do that.
Well, but
The state would submit to you that what this was an amateur attempt by Mr. Tellis to pull off his killing. But here's the thing.
Right.
It is thoughtful. It is deliberate. He really did a thoughtful job about it. I give him credit. I give him credit. But in the world of the digital age, we leave behind too many breadcrumbs. And when you're not a professional and you are an amateur, you tend to make mistakes. And that's what he did. For example, really smart idea. He knew about IBI Core. Hey, I've got a really easy way to look up personal identifying information on people. I'll use my work computer. But what does he not realize? That we can, as the police, download the computer and literally see your keystrokes.
He's a tech guy.
It's an
that was
oversight.
an
It's a
evidence.
mistake. It's a slip. And it's evidence that we collect against him. What else? He does the Google Maps surveillance. Really clever. What an easy way. You don't even have to go to the neighborhood. Just pull it up on your Google Maps. He does the Popeye surveillance. He takes the photos off his work computer, right? But he forgets to delete his cache files. And let's just make this clear once and for
that
all.
stuff really does
Matt
make it.
Hovanec told us
I
what?
think he was
He said,
planning
these
to
are not
make it
created
look
photos.
like he
They
was
would
trying
say
to make
created
it
in the
look like
date
he
and the
was
time,
being
and you have
planned.
it.
Wait, what are you saying? Sounds
I
like you're
think
saying
he
really good
decided to
stuff.
make it look like that was his plan. I'm going to pretend I'm being framed. So I'm going to leave all this shit where people can find it. I don't know. I mean, his answer for everything was like, I don't know that was there. Should prove it.
Yeah. Yeah. I mean, at the end of the day, nothing's more damning than the DNA under the fingernails and that horrific injury, which he tried to blame on making chicken fried rice.
What's Pammy saying? No, he said they. Oh, right. I know he said they planted the shit at his house.
Well, but that would also mean that they planted the shit on his devices.
I know, but that's
or
when was your phone missing? How are they doing that over time?
Or that they fudged the Cellebrite report.
That takes too many people.
It's a lot. It's a lot of people.
It's different when you're like, it's different when you're talking about like Karen Reed because that's cops covering for cops. You know, that's different.
Yeah, it's still a lot of people that have to keep quiet though. That's my problem with that. Like
Oh yeah,
just
all the
can't
people
shut
in the
their
house. you're
fucking
saying.
mouths. People cannot keep their mouths shut.
Yeah, but like we said, they could have been on the side of the house. You could have been
Who?
doing that in Reed. Like if there was a fight, it could have went down on the side of the house. Side back door.
Side back door? You mean the one where you don't walk up the stoop?
Mm-hmm.
The side?
By the fence.
Why would he come in that door though?
Maybe they called him over there. Hey, we're over here.
There's no way. The whole theory, the only way that theory works is that he saw the text between Higgins and Karen and got super pissed off and stormed in that house with the
well, then 10 people
with fire in his heart. And he
their
went
lives.
in, he had an axe to grind and he went in and started a fight right away, walking like as soon as he walked in. Like like that thing never worked with them trying to lure him in to beat his ass. That's like the most.
No, I don't think that.
Well, that's what you just said.
No, they could have been for maybe he saw them over there with taking the dog out, so he went that way instead of in the front
They let
door.
the dog out of the back. They don't let the dog out. Chloe never came out of the front. She went in the backyard. So that no, like there's only one way that ever was like because when I found out about the Higgins texts and then they went on for a couple weeks, I was like, all right, I could see like a drunk Irish cop that
You
gets in
keeping
a
an eye
fight
on the
with a
other
bunch
thing?
of what other thing?
Aren't we waiting
You
for a
talking
jury?
about yeah, what like the people will let us know.
Oh, the people will.
Dizzy watches everything back there.
That's
She's like the
she had
she's
said
like
that.
the
She said that right before you.
she's like the Wizard of Oz. She really is. She's the one behind the curtain making all the magic happen. That's who Dizzy is.
Oh, well, it's nap time.
I'm gonna have to start calling her the Wizzy of Oz. The Wiz. Yeah, there you go.
So I I was looking at this, and do you know that now if you're selling something, it means you're doing something wrong? That's
Wait, what?
the kids link. Because Scarlett was like, "You're selling my plan." I was like, "You mean like, are you trying to say I'm foiling it, like using it like that?" I was like, "Because otherwise, it's like I'm
What
really
plan?
pushing your plan." Whatever, I don't know, but I was like, "Wait, that means the opposite?" I
Soiling or foiling? She meant
She
foiling.
said selling.
Oh,
It's kid lingo now, apparently. Selling means more like you're pushing it off, you're getting rid of it. But
yeah, you're foiling it. You foiled my plan.
right.
Like I don't know what's up with kids thinking they could just change the
That's what I said. I was
definition of
like,
words.
"So who gets to make up what the words mean, and can I do it? Can I throw a couple in there? You guys will start
I mean,
using that
Jay's not
one?"
gonna like this, but don't make me bust out the dictionary because I'll do it. The big dick. That's what it's known affectionately in our
Well,
house. The
selling
big
is
dick.
getting rid of something, so you could use it like that. It's just never if you say you're really selling my story, everybody's that's not 12 is gonna think
Yeah,
you
but if you're
mean
selling a story, you're trying to get somebody to buy it.
I get it, Dave.
That's the use of that.
I understand, that's what I'm saying, that anyone over 12 is gonna think you're really pushing it. It's you're doing good, not you're screwing it up.
Yeah. No, I mean, look, the house was on the market before this shit went down, or they had a realtor looking at it. Like a lot of the stuff that was coming out, like I tried to avoid the noise as much
Nap
as
30.
possible and just really tried to focus on the evidence at trial with that
I'm
case.
coming to bed. I'm leaving you guys.
I think you should sleep in the spare.
Take a
Well,
nap.
I'm gonna probably so here's what I say we do. Um Diz, did they give us a time when they were talking about coming back? Uh in terms of Richins? Did they give us any kind of time frame? I don't know because I'm not sure.
What's it mean when it channels like the Lord of the Flies? Like they're acting creepy or they're all going wild or they're
Oh my
just
god,
dead?
yeah. No, what? The Lord of the Flies is where they take on like a herd mentality and like
Right.
become murderous. Yeah, that's true, Skylab. Welcome to the fam. That is not our community. Our
What are they
community is
lording the flies of? That the jury's still out on this thing?
oh, I don't know. I don't know. Like Skylab, are you talking about on Tayez or just in general? I mean, I poke my head in on the law and crime chat occasionally for like maybe 30 seconds and then
No, I mean I knew what Lord of the Flies was. I just was trying to figure out what she meant people were doing. Like that's why I was like they're going wild. Like
well, specifically about Tayez. That's what the question is like, is this what they're like? Yeah, we don't want an echo chamber. We're not an echo chamber. Plus,
nope.
hey, Trial TV. Aw,
Yeah.
family hug.
Thanks again, Trial TV.
Welcome. Yeah, I don't know. Yeah, no, we like to critically think over here. Like we like to, try
We're
to
trying to
probe.
critically think right now about how we could make Tellez Telez is. He doesn't deserve his Tellez since he threw it away. Story better.
Oh, okay. Let me see. I got a Venmo.
So I honestly, I do think that's a possibility that he decided that he's obviously going to be a suspect if this guy gets killed. So he's going to plan the perfect murder and frame himself for it.
Sheba so kindly sent us a $5 Venmo. Thank you very much. $5
Thanks,
holla.
Sheba.
Your conversations have really opened my eyes to the world of defense attorneys. I appreciate your perspectives and how you. Oh, wait, I got to actually open up the Venmo. The text doesn't really show you the whole thing. Let's see. And how you work together. I'm on the hunt for a My Cousin Vinny tux at thrift stores. You're going to wear it, right? 100%.
Wait, who's wearing what?
Sheba wants me to don the
There's
the
almost
ridiculous,
nothing you
the
can
ri-
put
ridic-
this.
there's almost
give
nothing
this-
that I won't wear.
Don't make it look awesome though.
Yeah, I mean, didn't you guys see me? When did I put on the zebra shirt?
No, we didn't like it.
I loved it.
We didn't like it.
Who's the
The
proverbial
chat.
we? I disagree.
The
I think
people.
there were plenty of people in
Not.
the
I
chat.
kind of remember nobody liking it. I
Sheba loved
tease.
it.
I tease.
Boo.
Everybody. I'm sure everybody loved it, and I thought you looked great. I
Yeah,
always
I
think you
mean,
look great.
You bought it for me, Chief. I mean, it was for Zebra Night on Jam Cruise. It definitely had Leslie. Thank you. Thank you. Yeah, exactly. Pammy, thank you.
I mean, if we're just gonna sit here and
The royal we
and verdict
pontificate.
watch, I think we need a soundtrack.
We can't play anything. You'll get us a copyright strike.
Oh,
That's why I never have music on here.
I'm super like jealous that I missed
Like, if
yesterday
they
for
allowed
no
us to play
reason.
music, like our channel would be the dopest dance party
Dopest.
of all time. Like if we had the ability to play whatever kind of music we wanted all the time, it would be next level.
I don't know why they don't just incorporate a thing where you can pay through YouTube, like so that where they're doing something like that, they figure out a way to make money on it themselves, and people get like a penny for their songs anyway. So
Well, and like so every time we see John Phillips, like I'm always driving home like about licensing that portion of justice for the morning
yeah,
trial.
but you told me that you're not sure how you would even tell YouTube that it's been.
Well, that's it. Like there has to be a way that if we've got license from the artist that we can use the music.
Well, I've seen them like when you're setting up the YouTube or when you're putting it, whatever. Maybe that's not for a live. Maybe that was for a video. Or I'm thinking of when we put up the podcasts. All right, never mind.
Yeah, I don't know.
I thought there was like a thing where it says, "Is any of the material copyrighted?" And if you clicked yes, that it would give you the option to say whether you got a license.
All right. Oh, our pins came for CrimeCon UK. I ordered some pins.
Well, you better get something.
I got pins.
Well, I feel like you might need more.
Well, we all have stories. All right. So I'm going to pull Tellez off. I'm going to go back to
Just the screen.
see what's up over here. Yeah, I mean, just so y'all know, despite all the super interesting probing by the judge and Richins, yeah, like this thing's going through. It's all getting bound over for trial. All the
I mean,
counts.
he basically said you're really benefiting from the low burden here. I don't think that second one. I mean,
it's a super low burden. And
yeah, but
remember,
it has
our
to
judge-
actually be a connection. It can't be completely speculative.
Well, I don't think it's that speculative. She bought the drugs 2 days prior from an illicit drug dealer. It happened to
Right.
be like to me the
But there was
biggest
something
problem-
about the text that made the judge not interpret it the way he was like, well, You could also read this like this. I don't know what he was talking about, but
To me, the biggest problem with that charge is the fact that he did not go to the hospital. So they're completely speculating on what made him sick.
right.
That's, to me, that's the big problem. Like, they don't know that he almost died from fentanyl. Like, that's total speculation. I don't know that they're going to be able to prove that at trial. They're going to be able to have the breadcrumbs. You know, they're going to have this. She purchased them. She went and got the meat. She leaves the sandwich in the truck. Yeah, I don't think she went into the house. I didn't know what her lawyer was talking
If
about.
he doesn't bind it over, I don't see how he could find that it could be used as 404B, because there's almost more. I can't remember the burdens. I think more than like reasonable doubt. I mean, reasonable doubt, probable cause.
For
You have to
what?
show like might be clear and convincing or something
For what?
to get 404B evidence in. You have to show it actually happened. All right, I got to go to bed.
Yeah, Allie was up all night working.
I can't think straight. My brain's done.
I know the whole like Tea's like Photoshop thing made that.
Oh,
very-
what was crazy was on the other picture, the one where it's like the real picture that they're trying to say is him. All it looked like to me at some point was just a gray, like a cardboard box. And then I went to take a picture of it and I thought, well, that's silly. It only looks like that to me right now because I haven't slept. No, the stream's not going to end.
No,
Wait.
I think Dizzy was talking about.
Oh,
No, I'm seeing a "We Will Be Right Back" screen on there, Diz. I think they're coming back.
I'm going to come lay in there anyway. I'll end up chirping in. Then you'll just tell me to stop speaking because people can't hear me. Only you can. All right. Love you guys.
All right, love you, babe.
I'll see you in a second.
You're the best. All right. Let's see. Yeah, that was definitely interesting with the with that little that Photoshop hoodie thing. I mean, but you can Photoshop anything. Just Photoshop anything, you know? I don't know. Plus, that doesn't matter. The jury didn't see that shit. So, like, they don't even have that as a thought in their mind. I mean, look, my head's going to explode on a live if they come back with not guilty on that case. Like, I'll just flat out say it. It's like, there's no way. There is no way. But, you know, I mean, they're going through the process. I respect it. I obviously respect it. I mean, shit, they got to be 7 hours in now. You know, they're going through it, checking it all out. I cannot see. Well, I was going to say I can't see it going past today, but I can actually. I mean, what time? Well, it's 12:50 Pacific time, so probably just got the pizza in there. They're all snarfing some pizza, talking shit. There's the one antagonizer that's playing the Henry Fonda role, like from 12 Angry Men, giving ponderables out. Here's a ponderable. So, I mean, like I was saying, if you're late to the stream, I really feel like you got to shut that door, babe. Let's watch this while we're killing time. Watch that. All right, so it's the cross. Oh, plus we get the Tejas deliberations clock. What? It's a double bonus. So if you guys don't know, Lil Wu still on the stand, except now he's under cross-examination
First lawyer, second lawyer. Which?
by Jeffrey's lawyer, the main defendants.
Does he go? Did he go first? Do you think?
Yeah, I do.
Can you guys hear me when I chirp in over here?
It started yesterday. Let's get some context here. Oh, what? What the hell? Is that a commercial? No.
I'll do whatever, man. I'm glad you mentioned it.
Wait.
Did you just say I'll do anything, but I gotta
What?
sell it?
Okay, this
And who stays
wrong
out?
one.
All in
wrong.
one.
I don't know what that is. Where's my premium?
You're in your premium. I see it.
Where?
I see a little picture of Defense Diaries in the corner.
But that's YouTube premium. No, I'm talking about let me see. Let's see what's going on here. There's all of my creator homies I support. Let's see.
None of them.
I don't know what.
Why don't you start going through your email? That'll entertain the people.
Yeah. If I go through your email, that'll really entertain the people. Yeah, I have zero interest in watching Wade Wilson.
Who's Wade Wilson?
He's the monster. Guy's a monster.
Who'd he
It says
kill?
purchased. I don't understand what the hell is going on with this.
Purchased? They decided they had to start charging for Woody.
Yeah, but like, why do I have commercials?
I didn't see it.
If this is what you would
Yeah, what the hell?
Maybe Long Prime is putting it right on the feed.
get, Birdman, we want to talk about the darn, or it says, damn, Wayne Bus. I want to play that for you. Tell me if this is what you were told.
So what can I do to just make it straight to it? Oh, I will. Well, I do whatever, man. I will.
Wait.
I do whatever, man. I'm glad you mentioned it. I'll do whatever, man.
Wait, they cut what feed, y'all? They cut the Richins feed? Is that what you guys are saying? Or they cut the
Woody feed.
the YSL feed? Let me see. Dizzy's in private. Okay. Let's see. Richens feed. Read the chat. Like, CH. You're telling me to read the chat? No. Trying to do a million things over here. You guys know how tech challenged I am. I do the best I can read the chat. Oh, I love y'all. You're such a fun, cute couple.
Oh, you can find that.
We love you back.
You can find that, but not whatever.
Well, that one was starred.
Oh.
Those are easy to find. All right. So what are y'all saying? Cool. Thanks,
Richardson is
Dizzy.
on.
Wade is being sentenced at 4. Okay. Death penalty. I want to take away all the mystery on Wade Wilson. Let's see. Let's see. Disease. They cut. Oh, did they? So what are you telling me to do, Des? So you go to Trial TV's channel? Trial TV, do you guys have it?
Can't go anywhere.
Let's see.
Preliminary hearing is to show probable cause for each offense charged.
Oh shit, are we back? Oh, thank God for once again, thank God for Trial TV Live. And okay. All right, so this is what we're about to do. Okay. If you guys have not subbed to our friends at Trial TV Live, get your booties over there and hit that sub button. Let's go.
And Houseplant.
And Houseplant, our music friends. All right, so Their sound sounds better too, which Dizzy told me about 3 hours ago. Okay.
I confirm that as a matter of law.
Okay. Yeah, sound is better. Trial TV coming through in the clutch. I don't know why it. Oh, maybe this is. I gotta do a bloop 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 bloop. Okay, bloop bloop bloop. Okay.
Ms. Nestor, we had a conversation before the break about the merger doctrine. I confirm that as a matter of law, merger does not apply before trial. And in fact, the protections provided by the merger doctrine are not applicable before trial. The trial court cannot assess whether, under the particular facts of the case, one charge merges into another until the prosecution has presented its case and the jury has convicted the defendant of multiple charges. Thus, under State v. Lopez, 2004 Utah Ave. 410.
Thank you, Your Honor.
Which brings us to a discussion of what we are and are not doing today. First, what we're not doing. We are not determining in any degree guilt at all. Ms. Richins was presumed innocent of all charges yesterday. She is presumed innocent of all charges today, and she will remain presumed innocent of all charges through trial. Nothing the court says today affects her presumption of innocence in any way. Preliminary hearing is a specific thing with a specific legal standard. The state's burden at a preliminary hearing is to show probable cause for each offense charged, and the court must bind a defendant over for trial if the prosecution presents evidence sufficient to support a reasonable belief that an offense has been committed and that the defendant committed it. So even though the Utah Constitution provides criminal defendants with a fundamental right to a preliminary hearing, the evidentiary threshold at such a hearing is relatively low. At this stage of a criminal proceeding, the prosecution need not eliminate alternative inferences that could be drawn from the evidence in favor of the defense. And in reaching the bind-over decision, the court must refrain from assessing whether the prosecution's inference is more plausible than an alternative that cuts in favor of the defense. Instead, the court must view all evidence in the light most favorable to the prosecution and must draw all reasonable inferences in favor of the prosecution. And the court must leave all weighing of credible but conflicting evidence to the jury. Here, having reviewed the evidence admitted, including the 1102 statements, the documentary exhibits that were pre-admitted, having considered the admissible sworn testimony of witnesses that testified live, the court reaches the following determinations. First, for the reasons described at the detention hearing, which remain valid today, the prosecution has shown probable cause that count 1, aggravated murder, and count 3, distribution of a controlled substance, both of which relate to events that are alleged to have occurred on or about March 3rd and 4th of 2022, are supported by probable cause. Ms. Richins is bound over for trial on counts 1 and 3. With respect to count 2, attempted aggravated murder, alleged to have occurred on February 14 of 2022, the prosecution has admitted evidence sufficient to support a reasonable belief of the following facts and events. That in January of 2022, Kouri Richins secured a life insurance policy on her husband's death, or her husband's life, through fraudulent means. That she had a significant financial incentive to secure his death because she would do better under the premarital agreement if he were dead, and her businesses were highly leveraged.
Wait, dude.
Then on February 14, she purchased.
What?
I'm just saying, I think he could find what they didn't find is
Can
that
you
a
guys hear
crime
her?
occurred.
She's talking over here on the side. Can you guys hear Allie? Saying super smart shit, but I just want to make sure you guys can hear it.
Shit. Don't say I'm saying smart shit when I'm saying stupid shit.
No, you're definitely not saying smart shit.
But he could
He could definitely. Like that's exactly what I was saying. They didn't really establish that a crime had occurred.
All they established is that if a crime occurred, she's the motherfucker that did it.
Right, exactly. If a crime did occur, she the one. She the one.
Just food for them both, including him. She described it as lunch in her text message to her friend in June. She was not honest about where she was going that day or what she was doing after she left the family home. Eric had a significant reaction to something that day, sufficient to make him consider going to the hospital. The state has admitted evidence that fentanyl can cause a serious reaction. There's significant evidence, at least, to support a probable cause finding that Ms. Richins had secured fentanyl by February 11th, and that on or about February 26th, she contacted her source again and said she needed something stronger. These facts taken together would support issuance of a search warrant to investigate whether Ms. Richins had attempted to cause the death of her husband. They would support issuance of an arrest warrant for her arrest on attempted murder. And they are.
Y'all are about to have your mind blown.
Well, I think they already did.
I don't know if they know what's going on right now. So he's about.
I think they know.
He's about to find that they don't have the.
No 2, no 4, baby.
There's no 2, no 4.
Are sufficient to support bind over under the probable cause standard for attempted aggravated murder on February 14, 2022. The court makes this determination without considering the probable cause that indicates that Ms. Richins actually caused the death of her husband on March 4th. And so while the court is considering evidence of statements made by Ms. Richins and actions taken by Ms. Richins after February 14th, it is not that action. That is the alleged successful completion of the attempt. Rather, the actions and statements the court is considering that occurred after February 14 are her text messages to her paramour to the effect of, I wish he would just go away, or if my husband would just go away. Her contact with her source of controlled substances, seeking something stronger, which leads to a reasonable inference that the stuff she got before did not give her the results she wanted. And her statements on June 18, 2022 to her best friend that she provided a lunch. And this, of course, includes the evidence from the morning of February 14 that she did, in fact, buy food from the Mirror Lake Diner. Taken together, viewed in the evidence in the light most reasonable to the state, drawing all reasonable inferences in the state's favor, this evidence supports a non-speculative inference that Ms. Richins attempted to murder her husband with fentanyl on February 14th. Having drawn that determination, it also requires the court to bind her over for trial on count 4, which is the distribution charge related to February 14th. We pause there before we get into the financial charges. Mr. Bloodworth, do you need any clarification of the court's ruling so far?
No, Your Honor, thank you.
I do.
Ms. Lewis?
No.
Okay. All right. Count 6 and 7, mortgage fraud with respect to the iron.
No one attempted murder, yes on distribution.
He bound her over on 4, but not on 2.
Right. So he's saying,
I want to hear it again.
all right.
Like, the reason I want to hear this again, because you just don't see this shit very often. Like, typically, this is like, much like grand juries, this is typically a rubber stamp.
Nothing the court says today affects her presumption of innocence in any way. Preliminary hearing is a specific thing with a specific legal standard. The state's burden at a preliminary hearing is to show probable cause for each offense charged.
All right, Allie just said that nobody wants to hear this part again. Is that true? No one wants to hear this part again?
Well, don't we want to get right back to the
See,
part-
Dizzy's saying count 2 is bound over.
Yeah.
I thought that,
What?
no, bound over means it's going to
I
trial.
know. Thank
Dizzy's
you.
saying 2 to 11 are all bound over.
I thought he said no on attempt.
That's why I'm playing it again.
Oh.
Let's see. All right,
So why would he have needed to clarify anything for anyone?
The court must bind a defendant over for trial if the prosecution presents evidence sufficient to support
Why'd it go? Oh, it confused me. It got real.
a reasonable belief that an offense has been committed and that the defendant committed it. So even though the Utah Constitution provides criminal defendants with a fundamental right to a preliminary hearing, the evidentiary threshold at such a hearing is relatively low. At this stage of a criminal proceeding, the prosecution need not eliminate alternative inferences that could be drawn from the evidence in favor of the defense. And in reaching the bind-over decision, the court must refrain from assessing whether the prosecution's inference is more plausible than an alternative that cuts in favor of the defense. Instead, the court must view all evidence in the light most favorable to the prosecution and must draw all reasonable inferences in favor of the prosecution. And the court must leave all weighing of credible but conflicting evidence to the jury. Here, having reviewed the evidence admitted, including the 1102 statements, the documentary exhibits that were pre-admitted, having considered the admissible sworn testimony of witnesses that testified live, the court reaches the following determinations. First, for the reasons described at the detention hearing, which remain valid today, the prosecution has shown probable cause that count 1, aggravated murder, and count 3, distribution of a controlled substance, both of which relate to events that are alleged to have occurred on or about March 3rd and 4th of 2022, are supported by probable cause. Ms. Richins is bound over for trial on counts 1 and 3. With respect to count 2, attempted aggravated murder, alleged to have occurred on February 14 of 2022, the prosecution has admitted evidence sufficient to support a reasonable belief of the following facts and events. That in January of 2022, Kouri Richins secured a life insurance policy on her husband's death, or her husband's life, through fraudulent means. That she had a significant financial incentive to secure his death because she would do better under the premarital agreement if he were dead, and her businesses were highly leveraged. Then on February 14, she purchased food for them both, including him. She described it as lunch in her text message to her friend in June. She was not honest about where she was going that day or what she was doing after she left the family home. Eric had a significant reaction to something that day, sufficient to make him consider going to the hospital. The state has admitted evidence that fentanyl can cause a serious reaction. There's significant evidence, at least, to support a probable cause finding that Ms. Richins had secured fentanyl by February 11th, and that on or about February 26th, she contacted her source again and said she needed something stronger. These facts taken together would support issuance of a search warrant to investigate whether Ms. Richins had attempted to cause the death of her husband. They would support issuance of an arrest warrant for her arrest on attempted murder, and they are sufficient to support bind over under the probable cause standard for attempted aggravated murder on February 14, 2022. The court makes this determination without considering the.
All right, so Dizzy's right. He's bound her over on, at this point, 1, 2, and 3.
And then he
The
did.
probable
And then he
cause
doesn't go.
that indicates that Ms. Richins actually caused the death of her husband on March 4th. And so while the court is considering evidence of statements made by Ms. Richins and actions taken by Ms. Richins after February 14th, it is not that action. That is the alleged successful completion of the attempt. Rather, the actions and statements the court is considering that occurred after February 14 are her text messages to her paramour to the effect of, I wish he would just go away, or if my husband would just go away. Her contact with her source of controlled substances, seeking something stronger, which leads to a reasonable inference that the stuff she got before did not give her the results she wanted. And her statements on June 18, 2022 to her best friend that she provided a lunch. And this, of course, includes the evidence from the morning of February 14 that she did, in fact, buy food from Mirror Lake Diner. Taken together, viewed in the evidence in the light most reasonable to the state, drawing all reasonable inferences in the state's favor, this evidence supports a non-speculative inference that Ms. Richins attempted to murder her husband with fentanyl on February 14th. Having drawn that determination, it also requires the court to bind her over trial on count 4, which is the distribution charge related to February 14th. We pause there before we get into the financial charges. Mr. Bloodworth, did you need clarification of the court's ruling so far?
No, Your Honor, thank you.
Ms. Lewis?
No.
Okay. All right. Count 6 and 7, mortgage fraud with respect to the Iron Bridge loan and the Boomerang Finance loan, respectively, are bound over. Counts 7 and 8, insurance fraud with respect to the $250,000 True Stage policy, and then a scheme with respect to the $100,000 True Stage life insurance policy, respectively, are bound over. What's that business?
I think you just said 6 and 7 and 7 and 8, and you skipped 5.
My apologies. 5 and 6 are Iron Bridge and Boomerang, respectively. 7 and 8 are the $250,000 two-stage policy, and the scheme related to the $100,000 true stage policy, respectively. 9, 10, and 11 are forgery counts related to the altered America First Credit Union account statement submitted in respect to the Iron Bridge and Boomerang Finance loans, and with number 11, the forged signature on the $100,000 True Stage life insurance application. Mr. Bloodworth, any clarification?
No, sir, thank you.
Ms. Nestor?
Yes, sir.
Okay. Let's pause there for a second. Ms. Nestor, Ms. Lewis, I imagine Ms. Richins would like to enter pleas of not guilty to all charges.
Correct, Your Honor.
Does she waive reading of the third amended information?
We waive reading.
All right. The court, Ms. Richins, is entering pleas of not guilty to counts 1 through 11 in the third amended information. Where would you like to go from here?
We'd like to set a trial date, Your Honor.
have you had a reasonably detailed conversation with the state about numbers of witnesses, length of time? Because I'm going to have some questions.
We have discussed it, and what we have agreed to, I don't know if it works with the court calendar, is we would like to set aside 4 weeks, basically the month of May, to try to do this. So we think that would include jury selection. So we figured the jury selection is going to be at least a week and 3 weeks for trial.
Have you given any thought to pre-trial motion practice?
We have
Discussion regarding jury selection. There's going to be some questions regarding preserving the integrity of the jury selection process.
Correct. We've discussed it. We haven't set particular dates for motions, although I believe we thought it would be two rounds of pre-trial briefing and motions, and we would need to do a scheduling on, or we need to do a scheduling order on those motions and briefs.
Can we start having those conversations regarding pretrial deadlines, maybe a pretrial conference in mid-September?
Yes. We're in trial until September 20th, though. So actually, if we could just do
Late
it
September.
after that.
Does that make sense, Mr. Glover?
Yes, sir.
Okay, give me just a moment. Yeah, that's my next question. Council, I have a couple of questions here. If you're not prepared to answer these, we can continue this discussion. But first, rather than the entire month of May, we just say the last week of April, the first 3 weeks of May.
We were a little bit worried because I think Easter's really late this year, and
Memorial Day is included in the day of some of your
right.
frying pan into the fire. More to the point, my signing week is the last week of May on Memorial Day. It could be tough for me to trade out of that.
I think we checked this. We were trying to avoid spring
Oh,
break.
excuse me. Hold on a second. Let's try this again. My apologies. Oh, it is there again. Did I get Memorial Day twice? Is that possible? Hold on a second. I did. We'll review who I pissed off to get that. Two questions. One, that will be hard to trade out of. Two, I need my Fridays.
Right. I think we took that into consideration when we decided we thought it would take 3 weeks.
Okay.
For counting jury selection. The only concern we had was about Easter week, that people traveled, and we were trying to avoid losing jurors who might travel over Easter. So that's why we started. I'd almost rather push it to the first week of June and take that day. Is it a week that you do that, whatever? Oh, I don't know what that is.
So Easter in 2025 is April 20th. I think we're going to be okay.
Okay, then we could do the last week of April.
So what I'm asking, is
That would work.
April 28th through May 22,
Right.
not including Fridays.
Right.
The idea being that jury selection would be April 28th through May 1. Say it again. Yeah. So then let's talk, We're gonna have lots of questions about how we're gonna do this. We're gonna have to, we'll have a discussion about whether we're doing half days each of those days for jury selection, whether we're gonna ask jurors to be available the whole day each of those days, we'll need to have a discussion about whether we're doing 4 veniries, 1 for each day.
Right, I do anticipate, Your Honor, there will be a lot of individual voir dire based on the,
I imagine. And so we'll want to be thoughtful about how many we ask to come each day.
right,
I'll need to reserve sufficient resources in terms of people power and jury selection slots. Third district policy is we do this using the virtual jury selection system. You're going to have to file a motion inside extraordinary circumstances. It's not my decision. Okay. We can have that discussion too. Yeah.
So right now, we need to take the 9:30 slot each day.
That's fine. Block it for now. We'll have a discussion. What's that? Just 80 each day. We can change the numbers later. Brittany, what do we have going on in the afternoon of September 27th? How many? Yes, 3 p.m. Yeah.
We said, one at 3 p.m. Short flag.
Counsel, are you available on the morning of the 26th? Or the 26th before, say, 2 p.m.?
I may be in a trial, would it be all right if I can't make it if this? Are you trying to get some?
We might both be in trial.
There's a chance we could be in trial that day, a chance. It's set for a 3-day trial, I'm sorry, it's set for 3 days and I think it's only gonna take 2. It's a trial down in Salt Lake. So we could just tentatively set it if it needs to.
Well,
In the afternoon, better, in case we can't wait on a jury or something.
all right, let's avoid that day. 27th is bad. What's the afternoon one?
If we could do it remotely, we could definitely, on the 26th,
In the morning or the afternoon?
in the afternoon would be better. I'm sure the judge would give us, if we need to step out and do take a break.
I've already moved the hearing once, I'm sorry. I can't do it in the afternoon.
Okay.
Bear with me. I'm sure this is like nails on a chalkboard to all of you, I apologize. So, we said something at 3 on the 26th.
We did. It's left. It's
Or we have a 1:30. Sorry, that's a mess. That's not too bad. What do we have on the 11th?
Indy Cindy, just to clarify for you, there was an attempt on his life which she has just been bound over for trial on Valentine's Day, in which she did serve him up a sandwich in which she had procured fentanyl on the 11th. Thought is that she crushed it up, put it in the sandwich. She took one bite, felt like shit, didn't eat any more of the sandwich, and then procured stronger fentanyl tablets or pills from the same drug dealer and successfully poisoned, or allegedly successfully poisoned, a Moscow Mule, in which she obviously purportedly put a lot more of the fentanyl in there, because ultimately that was when Eric Richins passed away. So 2 different occurrences.
For the, yeah. Okay. We're going to take that. Oh, goodness. Okay. Yeah. All right, council. The morning of
Exactly, Deja.
October 22. Nah, I can't do that. I'm sorry. My goodness. This is the problem. I'm going to have to put something out of the way. Ms. Richins, I apologize. I'm thinking about this the wrong way. Ms. Lewis, Ms. Nestor, I think we need to hold an initial.
I think every woman in that courtroom is crushing pretty hard on the judge. Just an observation.
Pre-trial conference to start talking through pre-trial deadlines and start talking about a jury selection. Tell me when you'd like to do it. I will make room.
30th of September, Monday.
I would unfortunately be out of state that whole week. That I can't fix.
What about October? It's not open. It's whole week. What about the afternoon of the 23rd?
Like later
Oh,
of September. September 23rd, later afternoon, like 3.
we'll make it work. Would you like that to be in person or by WebEx?
Whatever you prefer, will probably come up.
I'd prefer in person.
Yeah.
Is 3 p.m. workable?
Yes.
Okay, Mr. Glover.
Yes, sir.
All right, we'll set a pre-trial conference for September 23 at 3 p.m. in person.
Thank you.
Council, I need you to start talking to each other about issues you anticipate, pre-trial deadlines. I won't be able to see around every corner. I would appreciate your input, given your experience on how you'd like to conduct this. We need to start talking about jury selection. To the extent I'm going to have to ask for special treatment, favors, or to the extent you want to file motions to try and secure an exception from the standard practice in the 3rd district, we need to get rolling. I would prefer if you have notice of how you're going to be taking the jury in this case as early as possible. Okay. Mr. Bloodworth, anything to add?
No, Your Honor, thank you.
Ms. Lewis?
No, Your Honor.
Ms. Nestor?
No, sir, thank you.
Mr. Ramos? No, yes, thank you. Ms. Richins, I'll see you again on September 23 at 3 p.m. I wish you the best of luck. Court's in recess. Thank you.
All right. So y'all get it? Bound over on all counts 1 through 11. Yeah. Allie and I would like, it's funny when like judges rule like that, where they give a very thorough explanation, like Allie and I sitting at the table will be like, oh my God, he's going to grant it. oh my God, he's going to grant, or oh my God, he's, so anytime a judge kind of goes into a very thorough explanation like that, you start to think that one way or another, it's a sign of something, whether it's, him granting it or denying it or binding it over or not. It's always that thing where it's like I almost kind of prefer when they just kind of give the answer in that particular situation when they're ruling on something like that, as opposed to kind of like a law. Because Allie and I both thought initially when he was talking about count two that he wasn't binding it over. So, but obviously on replay, he's clearly binding it all over. And again, he was very careful to talk about, anything that he said there on the bench in no way affects her presumption of innocence. But at the end of the day, bound over all the charges. Trial is set for the end of April, up through the third week of May. And I'm thinking about going out there for that one, to be honest with you.
I might be telling her bench trial.
Yeah, Allie was thinking with this judge, I am beyond impressed with this judge. He is thoughtful. He's knowledgeable. He's got a great demeanor. Just a really, really good judge.
You can tell that lawyer how stupid she was for bringing up murder.
Yeah, he's got an excellent demeanor on the bench. He's thorough. He's everything that you want from a judge that's sitting on trials. He's very, very impressed with him. So yeah, might be spending some time out in Utah in late April. We'll see though. We'll see. Like I want to sit in on some of these trials. Obviously, I got to sit in on Delphi. I decided I might have to alternate weeks with Allie for Delphi. Have her do a week, I'll do a week. That way, neither one of us are away from the kids for that long. So, plus we get to come home on weekends. But we'll figure that out. Plus, it would be nice to have Allie's insight on certain days in trial. And it's too much for both of us to go, I think, at the same time, as much as I would love that. Be awesome to have Allie with me at that trial. Maybe we'll do a few days together for the Richard Allen trial, but just in considering the length of it, I think that it would be brutal to the kid. All right, so if y'all didn't catch it in the stream, we're gonna hang with our friends at Trial TV Live. They're going to play. You can see. I'm going to pull it back up. You can see the that's Sky Lazaro. That is Kouri Richins' former private counsel, and she withdrew kind of mysteriously a couple months back. And obviously there was a lot of shit going on with the walk the dog thing, the letter that they found that Kouri turned around and said, oh, that was just for a book. I was writing a book. Yeah. So yeah, that was her excuse for writing that letter. And she was intimating that her lawyer is the one who put her up to writing it. So I think Sky took some serious exception to that. I think the attorney-client relationship probably dissolved to the point where it could not move forward. But this should be heartbreaking, as we're going to hear from Eric's, I believe, sister, who gave this victim impact statement when the judge was determining whether or not he was going to be willing to give her bond.
He did not.
No. Oh. That's on me. You guys can see my hands are right here. Let's see.
I mean, they have to find that the presumption's great.
I think Trial TV, that's Trial TV that was, oh, jeez, look at him with the beard. Wow. Huh?
The
Yes, I would
fundamental
object.
fairness for the defendant, and without having to address the need to
You guys
postpone
can't
or
hear it?
continue this detention hearing, I am not going to consider that phone call. State's Exhibit 1 is in. State's Exhibit 3, for the purposes of this detention hearing, is not.
Okay.
Okay.
And Your Honor, we have no further witnesses. However, we do have a victim impact statement from the victim representative.
And if you could just name that person for us.
That's Amy Richins.
Amy, if you don't mind stepping forward to the podium. Good morning. Go ahead.
Dear Judge Mrazek, I'm here today to represent my brother, Eric Eugene Richins, whose life was taken in a senseless act of poisoning on March 3rd, 2022. His wife, the defendant, has been accused of committing this crime. If she is found guilty, she has committed the ultimate act of betrayal. Eric is gone, and I am brokenhearted. He was my best friend and protector. The feeling of loss is so great it is visceral. And with the sorrow comes a wave of panic at not being able to see him again. I can never talk to him, never hug him again, and never more be a part of his life. Eric's world revolved around his family, his love for hunting, the family cattle ranch, and his intense drive as a successful entrepreneur. Being born into the Richins legacy shaped Eric's formative years and resulted in a lifetime of hard work, dedication, and fierce loyalty. At an early age, Eric learned the joys of keeping horses and cows around. He spent countless hours at work the ranch, hauling hay, feeding the animals, and mending fences. He loved our family unconditionally and was a devoted son, brother, uncle, and father. Eric was a family man who always strove to be the absolute best father and husband. He was an attentive and loving father to his 3 sons and a devoted husband to his wife of almost 9 years, Kouri, the defendant. Eric did absolutely everything in his power to provide his family and his 3 sons with every possible to grow and have fun. He was the coach or assistant coach on all his boys' teams, which included soccer, basketball, and baseball. He spent countless hours coaching and teaching the boys to play aggressive and give it their all. Eric truly cared about every single child he coached and wanted the absolute best for all of them. There was never a dull moment when you were around Eric, whether it was him showing up to a family dinner with no socks or because he had to make an emergency bathroom stop along the way, or his calling to tell you he rolled the 4-wheeler for the upteenth time is stuck and he needs you to come get him. It was never boring. Eric loved to have fun and always wanted to make sure everyone else did as well. He owned almost every motorized toy possible, from 4-wheelers and side-by-sides to trucks and snowmobiles, and was so excited to share those with his sons. He had the perfect combination of business sense and foresight. He built a very successful masonry business from the ground up and helped many friends do the same. He had a special ability to build close relationships with everyone he worked with, which really allowed his business to thrive. Eric loved every aspect of his job, but most of all, he loved the people he worked for. Eric faithfully supported organizations that he truly believed in. He never was one that wanted recognition or accolades. He did most things anonymously and without recognition. Eric was a true champion of all. It did not matter if you were an employee, friend, family, or the next random person walking down the street. If you needed anything, you could count on him. He truly cared about each person he met. Eric loved fully, laughed loudly, and lived life. He enjoyed great adventures to far-off places, but also cherished the small and finer things in life. No obstacle was too great for Eric. He simply viewed each one as a challenge. No peak was too high, and the next adventure was always just around the next bend. Words cannot describe the loneliness and loss that is felt in every heart that was lucky enough to know him. Eric was such an inspiration and role model for us all. His loss has created a Grand Canyon-sized hole in this community. Except instead of taking millions of years to slowly form, our worlds change overnight. His 3 boys' entire worlds and their perspectives on life changed. None of our lives will ever be the same. Eric died under horrendous circumstances. I am tormented at the thought of what he endured. I play it out in my mind. I go through the terrible sequence of events. I wonder when he realized he was in mortal danger. It may have said to him in his last moments. How long was he conscious, knowing he would die? Where were Eric? Did they hear Eric's body fall to the ground? Did they catch a glimpse of their father taking his last breath? It's torture to think of. Why did Eric lose his life? Why did the boys lose their father? Was it because of Kouri's greed and desire to get life insurance and other assets? If so, that is abhorrent. How could anyone value human life so cheaply? I cannot comprehend it. I'm overflowing with grief and pain at the thought that Eric meant so little to her. If Eric had died because of an illness, he would have been cared for. He could have looked after him and been with him. If he had died because of an accident, people would have tried to help. There would have been kindness. But there's to be had here. There's no concern. In his last moments, after being intentionally poisoned, he was faced with betrayal and terror. The thought of it is unbearable. I am haunted by the horror of it. It has been a living hell for our family. We have watched as Kouri has paraded around portraying herself as a grieving widow and victim while trying to profit from the death of my brother. Both by trying to profit from a book about his death and trying to get life insurance and assets that should go exactly where Eric wanted them to.
Trying to figure out what that
his
glitching
boys.
is. I don't know. That's not on my end.
Immediately
Trial TV,
killed,
is that glitching
Kouri
on
told
your
us
thing
she could
too?
not help us get anything ready for the funeral as she was too distraught with grief. We shortly found out that was not true at all. In fact, she pulled herself off to go close on the purchase of a $2 million home, hire a real estate agent, hire an architect to create CAD drawings of the home, hire a lawyer in order to file a lawsuit on Eric's trust, hire a locksmith to come break into and clean out my brother's safe, and attempt to have Eric cremated. She mustered up the strength and resolve to do most of this within 48 hours of his death. Kouri assaulted me. I will never forget the look in her eyes when she attacked me that Sunday morning. It was early and had been snowing most of the night. I was just getting ready to leave and heading out to the car when I saw a locksmith in Eric's detached garage starting to drill out his gun safe. I asked Kouri multiple times why we could not just call my dad for the code. I could not understand why she was breaking into and ruining Eric's safe. To this, she screamed at me at the top of her lungs, called me some inappropriate things I cannot share with you here, and then told me to get out of her house. It was then that I told her that she could not kick me out of my brother's house. My sister Katie was now the executor of Eric's trust and estate, and just like Eric, she would not want the defendant breaking into his gun safe. Kouri looked at me with pure hatred and rage. I was messing up her plan. I was getting in her way, and because of that, she attacked me. Multiple times. It took 4 people to pull her off me that day. Before the funeral, Kouri opened a bank account and asked everyone that was grieving to send her money instead of sending the family cards and flowers. 2 weeks after Eric's passing, that we were told she had taken down my brother and removed all his clothing from the house. Kouri put together a golf tournament in Eric's name 2 months after his death on what would have been his 40th birthday, and told his family, all of us, that we were not allowed to attend. Since Eric's death, it has come to our attention that Kouri took out multiple life insurance policies on Eric without his knowledge. It appears that she forged his signature on various documents, assigned herself as Eric's durable power of attorney, inappropriately diverted money from his business to herself, and assigned herself as beneficiary of Eric's portion of our mother's retirement account. I should also not forget to mention the multiple life insurances she has taken out on the boys. Her most recent business venture was authoring a children's book about how to help grieving children cope with the loss of the death of a parent. In this book, she had the audacity to use the boys' real names and even use their last family portrait. Her behavior gives me great concern, as she has exploited the boys for money and will likely do so again. In addition, Kouri has weaponized Eric's children, manipulating my dad to do or not do things by threatening to cut him out of their lives if he did not capitulate to her demands. She similarly deprived the boys of contact with myself, my sister, and her daughters, unless we agreed to give her the money in Eric's trust. Money that Eric wanted to go to his 3 children. As if that were not enough, I've been told that Kouri started telling their 3 little boys that none of Eric's family or friends loved them. She apparently told them none of us cared for them or wanted to be around them, even though that is the exact opposite of what was happening. We all want nothing more than to be there for those 3 little boys, my nephews, yet Kouri has made sure to cut us out of every aspect of their lives. This is all just a brief summary and the start of what our family has been through over the last year. We have scarcely gone a day without finding out some new allegations or evidence regarding something Kouri appears to have maliciously done to attack and undermine my brother, his 3 little boys, and our family. We have all been there since the beginning of Kouri's and Eric's relationship. I was there on one of their first dates. We were there at the wedding. We were there when each of the boys were born. We have been there for every birthday party, school graduation, and rodeo. We welcomed her into our family and treated her as one of us. Not only did she betray our brother, it feels as though she has murdered and taken away a part of our souls as well. Because of her actions, there has not been a day that has gone by we have not lived with paralyzing anxiety and fear, worrying for the boys' lives as well as our own. I may be naive, but I never knew evil like this existed. I was in fact willing to kill Eric for money. Who's to say that what she will not do? Who would be next? Kouri was in a desperate financial situation when Eric was killed, and that situation seems even worse now. We understand that she has defaulted on loans and is already a defendant in other lawsuits based on her financial misdeeds. I am truly concerned that she will stop at nothing to dig her way out of the problems, including murder. She seems devoid of moral sensibility, and there is no telling what she will do if she is released. Judge Mrazek, her fate lies in your hands. Please do not allow Kouri to use the fraudulent life insurance proceeds to get out on bail. That would be morally reprehensible. Please do not allow Kouri to take advantage and make a mockery of our justice and legal system anymore. She has done enough. Please do not allow Kouri to hurt Eric's memory, our family, friends, and community anymore. We have been through enough. Please do not give Kouri the opportunity to hurt Eric's 3 boys anymore. They have lost enough and have been through enough. Since Eric's death, we have learned and unfortunately are continually reminded that Kouri is desperate, greedy, and extremely manipulative. Out on bail, I will be afraid not only for my own life and those of all of my family, but most for the lives of Eric's 3 sons. Has already suffered enough. Please do not let Kouri out on bail where she will be a risk to do further harm. Please protect what Eric put his life on the line for, his 3 boys. Thank you.
Amy, thank you. Ms. Cassell.
Nothing further on.
Okay. Ms. Lazaro, is the defense calling any witnesses?
I am not. I guess what I'd like to do is just largely have the court review the briefing and the attached exhibits be submitted and considered as part of this, but I don't intend to put on any further evidence.
All right. Would you like an opportunity to make any closing argument for today, Ms. Lazaro?
Yes.
Why don't we have defense go first and we'll just give the state the last word?
Thank you.
Okay.
I guess I'd start with whether or not the court has any specific issues they would like me to address.
No, I mean, candidly, there's a threshold legal issue here, right, that comes out of the briefing, and the state has been candid about the pending Barnett case. I listened to the oral arguments. I think the state is wise to request a ruling in the alternative, but I'm persuaded by the defendant's position that as a matter of law, while a defendant charged with a capital felony supported by substantial evidence does not have a right, they can nonetheless request bail, and the district court retains discretion, at least under the current status of the Utah Code, to consider the request. So fast forward past that.
I will do so. And don't necessarily disagree with what may or may come out of that case that's up on appeal.
Right.
With regard to the sufficiency of the evidence, I mean, we're here because of a really tragic circumstance, and I don't think any of us want to forget that. I mean, especially my client. She loved her kids, she loved her husband, but she's also charged now with his murder. And so I just don't necessarily want that to get lost on the court, that we understand the gravity of the situation. With regard to the evidence, I'm going to skip through most of it. I think the most important thing, if she poisoned him, is did she ever get it from CL? Was it ever requested from CL? I don't think the state has been able to draw that nexus. I don't disagree that CL was buying drugs. I think that's clear. She has a history of being a drug distributor. She was jammed with first-degree felonies. She had a potential federal case hanging over her. And, you know, then when they look at her phone, they find evidence of additional drug distribution. We knew charge. Pursuant to essentially the detective's testimony, is they walked her down the line of, I need more evidence. This is what we need to know. And provided evidence to her essentially until she got it right. And then she was released. When we look at the cell phone mapping, yes, we know she went and picked up a check. We know that she was cleaning houses. We know she cashed a check. We know she picked up drugs. But they can't put her anywhere in the same vicinity of Kouri's phone. Because apparently the mapping's not available from Verizon, which somewhat surprises me, given it's Verizon.
I think it's a length of time between the event and the request.
Correct. But they have cross things about her buying and selling fentanyl. They have zero corroborating evidence for anything. Kouri, for giving it to Kouri. She didn't tell anybody that she was buying it for Kouri. She never had anybody with her when she dropped it off. There's nothing to make the most important correlation in this, and that's that it was ever provided to Kouri that there was no fentanyl or traces of fentanyl found in the home anywhere. And I think that's significant. I think if she gotten 30 pills on at least 2 separate occasions, that's a lot of fentanyl. I mean, if one's lethal, right, we're talking about a lot of fentanyl, and nothing is found, no traces anywhere, absolutely nothing. So I think the state's making a big leap in their evidence by saying, look, we have this girl, we know she's a drug dealer, we know she's buying fentanyl, but there's nothing to corroborate anything she says that ties it to Kouri. The glass, Kouri tells them she made him a drink, right? The glass is there. No one thinks to bother to.
Where's the evidence that the glass is present?
Well, I didn't look for a glass, I guess is what I should say.
Okay.
So no glass was tested. So there's nothing to show that Kouri did anything to Eric. Detective O'Driscoll's testimony, it could have been accidental. I mean, it very well could have. And I think that given the evidence presented today is a very plausible situation. With money does not make you a murderer. Being bad at managing your accounts, makes you bad at math, but it doesn't make you a murderer. The other thing I think that's significant is by the testimony that came out today, the hard money loans that she owed, at least, far exceeded life insurance policy. And so even getting the life insurance money was not going to solve Kouri's problems, not even close to solving her problems. And so that evidence alone, while, maybe there's some other issues with Kouri's business, there's nothing to tie it to her having any motive or in any way being in a better position from Eric's death. In fact, she's in a worse position because of his death, because Eric had a business. He was continually making money. He was, from what it sounds like, the majority of the contributions into the joint account. So his death, from a financial perspective, has harmed her far more than any money that she gained from any life insurance. I'll largely submit on the remainder of our briefing, as I trust the court as well.
I have, carefully. Thank you. Ms. Cassell.
Thank you, Your Honor. With respect to the no corroborating evidence, there's a lot of corroborating evidence that corroborates CL's statements. And I think one of the things that we have that's said is, that she was primed and told what to say. But what really happened is she's, a year later, she's asked to consider what, if she remembered anything else, and she came back with, yeah, I remember more. And that's very typical of witnesses. It's typical of people that we have testified. And then you heard all of the corroborating evidence, Your Honor, the matching with the cell phone, with the mapping. Do we have CL putting the drug in Kouri's hands? We do. We have a hand-to-hand that was testified to. So we have the evidence that Kouri got, or the defendant got the drugs. We also have the evidence that corroborates all or most of CL's story. We would have more if there weren't texts that were deleted. We have a great deal of information that was deleted, and that was deleted off of the defendant's phone. So I think that is sufficient evidence just for CL, and that makes CL credible. Idea that no glass was tested. Well, if you look at the pictures that we have submitted, there's nothing there. It's a stage scene. How they can argue that Eric somehow consumed this himself? There's no glass. There's no baggies. There's nothing that this was ever taken by Eric. And also to say it's accidental,
That's a glitchy.
1 or 2 pills might be accidental. 20 or 5 times the lethal dose is not accidental, Your Honor. That is someone who wants Eric dead. And the person who benefited the most from Eric being dead is the defendant, or the person who thought she was going to benefit the most from Eric being the defendant. She thought she was going to be entitled to Eric's estate. She didn't know that there was this trust that had put the money into Katie Richins' thought on the day that Eric died that she was the one that was going to benefit. She benefited from the insurance policies. She thought she was going to benefit from more, and she thought she was going to benefit from Eric's estate. She tried to benefit from the other life insurance policy on Eric's business. That didn't happen. She also was in dire financial straits, Your Honor, writing checks on closed accounts or checks with no money in them. I know you cut me off.
It was in your brief. I got it.
I thank you. I understand. But that's significant because she was in dire financial straits. She was deep in debt. And the way to get out of that debt was to kill Eric Richens. She benefited financially, and she had many cases, and we talk about this all the time. Prosecutors say we don't need motive. This case has motive. This case has motive that she needed to get out of this debt, and that's the reason she killed Eric, in hopes of getting his estate, in hopes of getting his life insurance policies, and that, Your Honor, we believe is substantial evidence.
All right. The issue before the court is whether defendant Kouri Richins should continue to be held without bail during the pretrial period. Defendant is charged, among other crimes, with aggravated murder under Utah Code 76-5202 sub 2. To convict defendant of this charge, must prove beyond a reasonable doubt at trial defendant intentionally or knowingly caused the death of another individual under any one of the following circumstances: for pecuniary gain, or by means of the administration of a poison or of any lethal substance. Under Article 1, Section 8 of the Utah Constitution, a defendant charged with a capital offense has no right to bail if there is evidence to support the capital charge. And under Utah Code 7720-201 sub 3, a charge of aggravated murder is considered a capital felony for the purposes of determining bail during the period before the state makes an file a notice of intent to seek the death penalty. Accordingly, at this time, the aggravated murder charge in this case is considered a capital felony. Moving to the substantial evidence inquiry, consider the evidence offered by the parties, both through live testimony today and by documents attached to their briefs, which the court has reviewed at length. And having had the opportunity to weigh the credibility of that evidence, the court determines the state's evidence, notwithstanding contradictory evidence, could support a reasonable jury reaching a guilty verdict on the charge of aggravated murder. Indeed, a jury could reasonably choose to rely on the state's evidence regarding means and motive and consciousness of guilt, which includes evidence showing that Eric Richins died of fentanyl ingestion, that he was not known to be a user of illicit drugs other than the occasional, that defendant purchased 15 to 30 fentanyl pills from CL approximately 1 month prior to Eric Richins' death. Cell phone mapping confirms, or at least indicates to a reasonable jury, that CL's phone was near the Maverick and Draper on February 11th, and that while there, CL's phone made calls to acquaintances, capital A acquaintances, as listed in the testimony and the information, and sent texts to defendant Kouri Richins, and that CL's phone then traveled to Francis and then returned, was in Francis and then returned to Heber. CL's sworn testimony that she handed the fentanyl that she acquired to Kouri Richins in a hand-to-hand transaction in her driveway. We also have motive. At the time of Eric's death, defendant knew how the premarital agreement would operate, but was not aware that Eric had changed his estate plan. So at the time of Eric's death, defendant's subjective understanding was that she would get a greater share of marital estate if Eric died during the marriage, as opposed to what she would receive under the premarital agreement if the parties divorced. Moreover, evidence admitted in the case shows that in the months leading to Eric's death, defendant's personal and business accounts were overdrawn. She was making significant recurring debt payments, many of which were to hard money lenders, and that her lines of credit or lines of credit available to her were maxed out. And at the time of his death, Eric's life was insured for approximately $1.2 million, not including the policy related to the buy-sell agreement, with defendant listed as the beneficiary. Moreover, we have evidence from which a jury could reasonably infer consciousness of guilt. We have evidence regarding the search that was extracted from defendant's second phone after her first phone was seized. And then we have inconsistencies made by defendant as compared to other evidence in the case regarding whether she called 911 immediately, whether she performed CPR, whether she did something else for the 15 minutes between discovering Eric dead and calling 911. In considering this evidence, a jury could reasonably choose to discount and find unpersuasive defendant's efforts to poke holes in the state's case. And in so doing, a reasonable jury could reach a verdict of guilty beyond a reasonable doubt on the charge of aggravated murder based on the state's evidence. For these reasons, there is substantial evidence to support the capital felony charge of aggravated murder against the defendant in this case. Having made that determination, the court considers whether it has discretion to grant defendant bail, notwithstanding that she has no right to bail under Article 1, Section 8 of the Utah Constitution. And having considered the arguments and authorities cited in the parties' briefing, the court determines as a matter of law that in the case of a capital felony that is supported by substantial evidence, while a defendant does not have a right to bail, the defendant may nonetheless still request bail, and the district court has discretion to grant bail if the circumstances warrant doing so. But the circumstances of this case weigh soundly against granting pretrial release of any kind. First, defendant is charged as the death penalty and no less severe than an indeterminate prison term of 25 years to life. Of those sanctions, the severity of the sanction conviction for aggravated murder creates a powerful incentive for a defendant to resort to desperate acts that might include harming themselves, harming the members of their family, or harming witnesses in the case. Because an incentive this powerful cannot be adequately managed in the community, it weighs heavily against granting any form of pretrial release. Second, the state has offered substantial evidence that defendant procured fentanyl on more than one occasion, and on at least one occasion deployed that fentanyl to cause the death of another person. As a general matter, an individual who is capable of this kind of decision-making is not a good candidate for supervision in the community. More specifically, given the uniquely dangerous nature of fentanyl, which has been demonstrated tragically by events in Summit County, defendant's alleged conduct, as supported by substantial evidence, is especially dangerous. Indeed, these circumstances constitute clear and convincing evidence that defendant would pose a substantial danger to the community if released on bail, a substantial danger that cannot be adequately managed by any combination of conditions of pretrial release that are available.
See, he had written this all out. He's reading it. So that little lesson for you. I mean, judges certainly listen to arguments, but for the most part, they have a pretty damn good idea of what they're going to be ruling when they sit on that bench on any given morning.
Available in Summit County. For these reasons, the court finds the circumstances of this case, as supported by substantial evidence, weigh soundly against any form of pretrial release. The state's motion for detention is granted. Defendant Kouri Richins shall continue to be detained without during the time she awaits trial or other resolution of the criminal charges against her. Ms. Richins, you have the right to an expedited appeal of the. You must file a notice of appeal within 30 days of the court's ruling, and you have the right to be represented by counsel on that appeal. Let's pause there for a moment. Ms. Cassell, any questions?
No, Your Honor. Thank you.
Ms. Lazara,
No, Your Honor, thank you.
where do we go from? Are you prepared to set a preliminary?
I don't think so, because I think just based on the state's briefing and evidence provided, there's a lot of stuff that I don't have yet and probably need experts to look at, especially with regard to the phones.
Okay. What is a reasonable time to set a scheduling conference, understanding that I'm going to push counsel to move this case as fast as possible, given that Ms. Richins is in custody?
I understand that and appreciate it. I guess that question should be posed to the state as to when they think they can get me things. Like, I can't prepare without the evidence. I'm at their mercy at this point.
Can we check in on the 26th? Whether you think you've received everything?
I will, yes.
Do you want to do it in the morning or the afternoon?
Let me look.
All right.
26th of June?
Yeah.
We don't need that.
Oh, you know what? I'm sorry.
All right. So if y'all were confused, we wanted to go back. We wanted to check out some of the testimony and that super unusual event of a victim impact statement being given at a bond hearing when the judge is determining whether or not he's going to set a bail amount. I've never had that happen. I mean, it's an awful lot of, pretty declarative statements by the sister in terms of guilt prior to trial. So it's unusual. I don't know if that's a thing that they do in Utah. I've never had that happen at a bond hearing here in Illinois ever. So it's unusual, heartbreaking, but unusual. So, all right, here's what we're going to do. I'm going to dip. I'm going to keep an eye on Tellez or Tellus, whatever the hell you want to call the guy. Jury's still going for all we know. If you guys cannot figure out though that Kouri Richins thing is going to be a banger, it's got all the horrible shit that you want from a trial, horrible tragedy, and like Kouri Richins appears to be quite the monster, and it's not just her acts, it's the things that she did after, like the writing of the children's book and going on a book tour with it, and just the shit that she does. It's like, oh my God. Like I would argue she's one of the worst. It's like that kind of stuff is just crazy when you think about like people being capable of doing that kind of thing. It's just, I don't know. I don't know. Like she has very little ability to be able to have any kind of remorse for her actions. It's really, really weird. Oh yeah. Thanks, Diz. That's what I'll do. I'll port it a bill. But tonight, so I got a few announcements. If you're late and we've lost some crowd during the course of the day, which is to be expected, I'm going to set a portal up tonight. I have a very special show, a very, very special show with one of actually the first victim that was exonerated from the horrific acts of former dirty cop, Chicago homicide detective Reynaldo Guevara. I'm really excited about it. Jacques Rivera is going to be with Bill and I. He's going to tell his incredibly tragic tale, ultimately a tale of redemption. Like I said, he got paid out like $17.5 million from the city for all the misdeeds, for the lost life that he had. But he's going to be appointment television. I promise you that. So hopefully you guys, if you can't watch it live, if you're on the other side of the pond, or if it's a little late for you, if you're already battening down the hatches and in bed, replay it. We think that it'll be worth your time. And Dorsch, it's probably going to be a little bit of a love fest, because Dorsch doing what he did in terms of, really deciding to put his career and life at risk by being a whistleblower, something else. So, it's just one of those stories that I think are important. I think it's one of those stories that you guys should want to hear. It's definitely new content. It's like we can go listen to the same old, but I think it's important for y'all to kind of hear what's going out, or what happens out in this crazy world that we live in. So I'm going to redirect you to that live, but in the interim, actually what I'm going to do, take it back. What I'm going to do is I'm going to direct you. Let me get back in there. I'm going to direct you to Jay, because Jay is doing a live tonight earlier. So let me go in here and edit this. I want to take that one out. He is doing an Adelson. I think he's doing it tonight. I want to say, let me double check. Let me just see. Jay tweeted about it. I want to check it, so I want to direct you all there. Okay, so he's going live tonight for Charlie Adelson trial rewatch. So I'm going to direct you all there, and then I'm sure Jay will, in kind, direct you to me. And then what I'll do is I'll direct everybody to Publicly Buzzed, because I think that they're probably doing their weekly Tuesday night Phil Spector trial. And hopefully they're still going. I have to do it at 9. I hate butting up against my brothers, but I have very little say so in it, just because of the fact that Bill is in a very different time zone than I am. So, all right, I got that set up. So you guys are all going to get sent it over to Jay. Make sure you're checking out his Adelson replay of the trial. That'll be great. It's always great. And then make sure you're joining us tonight at 9 p.m. Central for hearing straight from an exoneree. Like, if you've never heard from somebody who spent a really long time in prison for some shit that they didn't do, you might want to check it out. it'll be pretty interesting. So, thank you to my mods. You guys are wonderful. Thank you specifically to Dizzy. You are my lifesaver. You are my everything. You are wonderful, Dizzy. Thank you for everything you do. And thank you for to all the mods, really. You guys are all wonderful. I appreciate you being there every day for us. It's wonderful. And thank you for everybody being so very generous. Nav, the EO, started it off with a bang with the 50 gifted memberships. Just unbelievable. We got some new fam. Sharon came in. Jennifer, always give her $10 holla. Missy, 10 months OG. Ashley, first day of her 3L year of law school, coming through with the $10 holla. Joanne, always give her, great member of this community, $2 holla. SC Shan, $2 holla. And then Dr. Vonda K, who I've been missing, came in with a late $10 holla, which we so appreciate. You guys are so generous. Really, really touches our hearts. So we're very, very thankful to all of you. Because without you guys, I'd just be an old man talking about lots and lots of cases. Love y'all. See you tonight at 9. This isn't a mistake. I forgot to say, unless we get a verdict in Tejas, then I'll see you before 9. If we find out there's a verdict, I'll frantically create a live and we'll be up for the Tejas verdict if that happens. All right. This time, for real. Later.